right, good morning, everyone. My name is Joaquin Esquivel. I'm Chair of the State Water Resources Control Board. Today is Tuesday, December 5th. It is 9 a.m., and I'd like to call this meeting to order. I'll begin by introducing my fellow board colleagues. With me here today is Vice Chair Doreen Diadamo, Board Member Nicole Morgan, Board Member Laurel Firestone, and Board Member Sean McGuire. With us as well is our Executive Director, Eileen Sobek, our two Chief Deputies, Jonathan Bishop and Eric Oppenheimer, our Chief Counsel, Michael Loffer. Our Clerk of the Board is Courtney Tyler, and assisting her today is Emily McShane and Michael Reed. This is a hybrid meeting, so it's both a virtual component and in person. For those of you joining us virtually, you're either viewing us through our customary webcast on the Cal EPA live website, or are viewing through the YouTube live stream. But if you intend on commenting on any comment on any of today's items, you need to be on the Zoom platform. There are instructions on how to do so at the top of the agenda. If you're having any challenges, though, getting onto the platform, please do email the clerk of the board at board.clerk@waterboards.ca.gov, and she'll help you get onto the platform. Once you are on, your camera will be off. You will be on mute until it is your turn to speak on the item you've indicated. For everyone in the room, good morning. Good to see you. We're here in Sacramento in the Cal EPA building. A few announcements for us here as well. If there happens to be an emergency, we will calmly file out through one of the exits over to Cesar Chavez Plaza. Once there, we'll wait for further instructions. Additionally, if you intend on commenting either at public forum or any of today's items, there is a QR code and also a tablet at the side of the room to be able to sign up for an item. Once you are in front of the mic, please do introduce yourself and any affiliation you are part of. Lastly, please do silence any phones just so that we have an uninterrupted conversation today. With that, this morning, before we get into public forum, we actually have a presentation of Superior Accomplishment Awards. We have two that will be going out this morning. And the first is from the Division of Information and Technology, and invite up Brian Bustos to be able to present this award. Good to see you. Oh, you should be invited to unmute. Apologies.
Okay, I think I'm unmuted.
Yeah, good morning.
Good morning, Chair Esquivel and members of the board. My name is Brian Bustos, and I'm an IT manager at the Water Boards in the Division of Technology, also known as DIT. I'm here to present the Superior Accomplishment Award to Don Ha, an IT specialist in our Application Development Unit. Don enhanced the SWRCB sanitary sewer system application to address the newly updated requirements for the General Order 2022-0103 DWQ. Don was able to develop the continuation of coverage and other features within 180 days of the board adoption. He coordinated with the program staff from multiple units and a diverse group of people to design, architect, and write the code. Therefore, Don's effort and dedication helped the sanitary sewer system application to be developed and compliant with the general order within a short period of time, an achievement deemed challenging. So a fun fact about Don. Don has been with the Water Board since 2007. That's 16 years, well over a decade, which speaks volumes about his dedication to the work he does and also the Water Boards. Don's truly a great person to work with. He's always there when we need him. So I value him as a coworker and a friend. So please join me in congratulating Don Ha on his significant contributions to the Water Board. Thank you.
Thank you, Mr. Bustos. I really appreciate you elevating Mr. Ha and his work. The systems that we depend on to have the decision-making, to respond to regulatory changes are so critical. It's how we interface with everyone. And so, Mr. Ha, your dedication to the institution, your work here is incredibly appreciated. I know from here at the dais for sure. So just thank you for that service.
Thank you all.
Thank you.
Thanks, Don.
And I believe we have one additional Superior Accomplishment Award, and would like to call up Mr. Eric Oppenheimer to present what is another very special award here.
This is good. Good morning, Chair, board members. Really pleased to be here today to present this gold level Superior Accomplishment Award on behalf of the Executive Office and the executive team to Courtney Tyler. This specific award is being given to her because of her work between August 2022 and August 2023, where we basically asked Courtney to do two jobs at the same time. And it was during just a very challenging time in the executive office in general. And she really stepped up, and you did more. We asked you to do more than we should have, and you did it with grace, you did it with diligence. And I think most importantly, you did it with kindness. And I think people really respond and appreciate that. Not only did she cover two jobs, but during that same period, she addressed a longstanding backlog of resolutions and orders and meeting minutes and got them posted to the website, something that had been a challenge for us for a long time. So she had cleared that out. She also helped us adapt to the transition. This is really during sort of the throes of coming out of COVID, and handled all this work while we were transitioning into this hybrid board meeting mode. And she did it all without missing a beat. And so, the job of the clerk to the board is really sort of keeping the trains on time when it comes to the administrative conduct of our board meetings. And it's a job that I know involves a lot of herding of cats and a lot of pestering people to meet deadlines. And I think it's a job where you can really annoy people and ruffle feathers. And one thing that I've learned is with Courtney is because the way she approaches the job, all we ever hear are compliments, how great Courtney is, how helpful she is. And I think that really speaks volumes to just her service here. And so again, on behalf of the executive team, the executive office, I want to thank you for your public service. You've just been exemplary. We admire you, we respect you, and I just want to congratulate you on this really well-deserved award. And there is also a monetary award you will be receiving.
Not to continue to make you feel uncomfortable, Courtney, because you are not one to be in the spotlight, I know, amongst this, but I just have to add my thanks. I know we had an incredible clerk of the board serving us, and to think that we could have someone even more incredible here before us just shows how much you stepped up in a real critical time for us. And for everyone on the outside, these board meetings can look like they just happen, that they are so well run, and we were able to bring everyone's feedback in because of some stroke of luck, and it's not. It's because of a lot of work and a lot of hours, and just want to extend my thanks amongst it too, and just really appreciate you, Courtney. Thank you. Here, let's take an awkward photo. Thanks, everyone. Really appreciate the opportunity to take the time to create just some gratitude here, especially for just great work. With that, we can move on to public forum. And I believe we have one public forum commenter that I know of for sure, and I don't have my list up here. and will leave requested about 10 minutes. And glad to welcome you up. And if you could, we don't usually have 10-minute public forum commenters. So if you try to keep it condensed as well, that can be very helpful for us. So thank you. If it's a green light on top, it should be on. Sorry.
Hi, thank you for giving me 10 minutes. Unfortunately, we've been through hell for 10 years. So I understand your 10 minutes. I speak fast, and this is going to be like a speed presentation. We have emailed you a million times, so I'm sure it's nice for you to put a face to a name. I'm the pain in the backside, Rafaela Woods from Wawado, the Water Warriors Against the Laurel. We're not having fun. We have no water. You have your teas, coffees, water, which I'm sure you grab from your tap. We don't have that luxury. And our bills are about $500 a month. I'm sure you wouldn't want to pay that. We don't want to pay that. So we need you to help us because the CPUC is getting us nowhere. And I'm sorry, I'm not crying. I have allergies. So CPUC got us nowhere. And last week, I don't know if Courtney had time, we got something right after their deadline, but we can provide you any paperwork that you want because we have a lot. And there's a lot more than what I'm going to say in the presentation. I'm just scratching the surface to make you understand what we are going through. I know you got emailed 169 impact statements, and I would really like to think that you read them. Those are written by our residents. Over half of our residents are senior on a fixed income. Carmen right here, who's come for moral support, she said, I'm not talking. She just used $39 worth of water, and she has a $186 bill for water we cannot drink, for water we don't have on a regular basis. Laurel knows me. She was a Springvillian. So we are from Springville. And I guess we are not in the most, in the poorest area in Tulare County. Luckily, some of us do well. We are not multimillionaires, and regardless, water is a human right. So it really doesn't matter. So I'm just I could go on forever. And I'm happy to if you want me to. I'm sure you shut me up at some point, but let's go on with the first slide. And as I said, this is just a snippet of what we are going through. Oh, okay. Oh, yeah, there you go. So this slide, all I want to show you is the Laurel has been sued successfully before. This is not the first time. It was sued in 2001. We thought it was a fluke. No, that's their habit. That's what they do. So, but also the reason why I put this map here is because it shows you that when they built a water system, you can see that our wells were in the floodplain or in the river already. They had 15 years and did nothing. Our biggest problem is that gray thing that you see kind of at the bottom in the legend. Basically, when we had the March catastrophic flood, we lost all our water for a really long time. Like we had absolutely no water for 15 days, nothing. We couldn't even flush our toilets, but we still got full bills. We thought it was just, an act of God. And then we realized, no, the Laurel's lack of care and incompetence, the flood wasn't their fault, but everything else was. They could have been prepared. They had no flood insurance. I think if you have 5 wells in the river, flood insurance is probably a good idea. And the Laurel says we're a private company. Then, sorry, the Laurel, suck it up and pay for flood insurance. And by the way, it's not on the slides. We've been charged for the loss of revenue from the Paradise fire. I think Paradise is closer to you than it is to us. We are 5 hours down south. Paradise is even further up than here, right? So why are we paying for the loss of revenue from Paradise? Anyway, let's move on to the next slide. Okay, well, I mean, we're in the Cal EPA building, so hopefully you can read that 621. That's not good. That's from a tap. No, actually, I take it back. That's when they put us on boil water notice. So the bottle on the left is actually the dirty water that the Laurel said you can go and drink. That's the result from the EPA kit 621, which is way above the contaminant level. And the disgusting gunky thing on the right is actually the Laurel's claiming that is our clean water. We just put electrolysis thing in it. And so it brings all the contaminants up. I don't know, we don't want to drink that, but that is what they claim is our clean water. And obviously, the Laurel is dirty in every possible way. So let's go to the next slide. The Laurel is willfully unprepared. There is a letter from, well, you can see probably better than me, from CPUC saying that the Laurel never had nor does he have an emergency plan. When we ask for an emergency plan, if you actually read the whole letter, all it tells is what Deloro has been doing. That's not what an emergency plan is. There was no plan, nothing. And there still isn't anything. And we're expecting another El Nino year. So, thank you. Deloro is cheap and willfully unprepared. That thing on the meter is a pressure gauge because we had no water pressure. We had no, even when we supposedly have water, we had no water overnight for about, depending between 12 and 14 hours a day. And so we complained, so they bought a cheap box from Walmart and put a pressure gauge on the fire hydrant. And to this day, we don't know what the pressure is. We had to send videos of no water coming out of our faucets to the Department of Drinking Water. And they said, but Deloro told us that you do have water. And I'm like, well, watch the video. And then they said, oh, you have no water. You are overwatering your plants. We're going to put you under stage 4 conservation. I don't know how you water with water you don't have, but of course, they believe Deloro because we are just, I don't know, I guess we just in it for fun. We're bored. We don't actually have, I mean, Carmen is retired. I also have a full-time job and a child with special needs. So Deloro is unable. I mean, I think it speaks for itself. They could not provide us water when we didn't have any. So Senator Shanna Grove had Crystal Guiders provide us some. And then once that water was gone for weeks, we just literally had no drinking water. Next slide. Deloro is greedy. I mean, yeah. Just we're in stage 5 conservation. They put a meter on a fire hydrant for a builder to build yet another house. And we're like, you can't do that. Even stage 4, you can't do that. And if you can see from the email, I got told, Miss Woods, they're metered like everyone else. No, they're not. My meter is not on a fire hydrant. I have a meter. And besides, when stage 5, you just don't give them any water to build. We don't need any more houses because we don't have any water for them. And below, as you well know, they need to send notices before they would turn the water off, but they didn't. Someone with an infant and a child, and they actually have a farm, which, you know, they're zoned for that, whether I agree with it or not. They just turn their water back, their water off at the meter the morning after the deadline for paying the bill without warning them. And they got back at night and they have a baby and they just have no water whatsoever and the animals have been without water. And then they got charged to turn the water back on. Yeah, Deloro is sloppy. Those are our wells. Yeah, I took those pictures. And then Deloro filed a criminal report saying that I messed around with the wells. I mean, honestly, I would be very curly-haired if I had, because, you know, that looks pretty dangerous. So 6 fuses blew. I would say that's probably one of the reasons why. And it was a $15 fix. And Deloro filed a criminal report against me, against us. So, yeah, it just keeps going. Yeah, next slide. Deloro is untruthful. Well, so I don't know if Courtney was able to add that to your paperwork, but here, so now we have a medical clinic wanting to come. Our water is not just really high in nitrates, which is a problem. Our water is unbelievably high in uranium and gross alpha, and always has been. We cannot boil our water, and yet Deloro says, this is, look at the date, November 14th. We are in stage 5. We've been in stage 4 since, what was it, August, September? I mean, for a really long time. He's telling the county, oh, we have plenty of water for them, but they don't. And so I don't know if I send it on, if you have it in your packet. I also have a letter from the CPUC saying Deloro is not issuing any more will serve letters because you don't have any water. No, they are. Deloro is lying. Yeah, sorry about that. But that's a veteran. He's senior, he's a veteran. Deloro does not deliver water to your house. Never mind water out of the tap. He went to pick up the water. It was too heavy. He fell. So that one is the picture before he had the surgery. This was back in beginning of October. Yeah, because I was gone. End of September, beginning of October. This foot, it was last week. Deloro is negligent. I mean, I think we've proven it already, but before you put mandatory conservation measures, you're supposed to have a public meeting. We have never had a public meeting. We had one public meeting in 2019, 2018, when Dolores had this treatment plant, this ridiculous treatment plant, which we are paying, we, not Dolores, we are paying $9.5 million for. Why? Because apparently you guys, because Dolores said it's all your fault, and you can go and watch the public meeting. Carmen and I organized a public meeting, and Dolores did us the courtesy of showing up. Go watch it, please, because apparently it's all your fault. So if it's all your fault, I'm really pissed at you. Like, it's that simple, because we have no water, and we're now paying $9.5 million for a treatment plant that was supposed to be in 2009, in 2018, in 2021, in 2023, in October, in November, we're in December of 2023, and we pay. We just pay for dirty water for a treatment plant that will be ownership of Dolores. They're a private company. Pay for your freaking plant, or just go. We just want them gone. We don't trust them. Anyway, you can see it. Consumer confidence reports are supposed to be delivered by mail or in person to every resident. We have never received one, ever. They publish them on the website. They've never organized a public meeting. Well, they organized one, and supposedly the water boards and CPUC were supposed to be present. You guys weren't present, CPUC wasn't present. You all relied on Dolores' minutes. Dolores has never, we've asked them, what's our contract with you? Like, what are your duties? What are our duties? We don't know. They refused to give it to us. They told us they're a private company. They don't have to give us anything. And then you see it. So since 2017, the guy with the injury, the veteran, bless his heart, kept every single piece of paper since he moved in. And so we got 17 notices for nitrates, 12 for uranium, and 0 for gross alpha. And I think if you go to the next slide, please, that's not the one. I had more to argue about. Dolores is arrogant. So when we had absolutely no water, the county and the city had offered to deliver water for free and no cost to Dolores. Dolores said, Robert Fortino, the owner of Dolores, said, that's futile. They're just going to waste it. And we had no water. So our rebuttal is below. This is our yard. I'm a real estate broker. Our prices are going to crap because everything is dying and because we have to disclose everything. So if our houses go to crap, the whole of Tulare County is basically gonna go down. It's probably one of the most expensive areas, but this is what we look at now, $500 a month. That's what we pay for. This is, obviously you can't read it, but everything in red is every time Dolores wells have been high in contamination. And I'm not talking, I think the level for uranium is 20. We're talking 46, 58, 53. By the way, none of Dolores wells are sealed at 50 feet, which is what we are drinking from irrigation wells. And you have apparently no record on when these wells became domestic wells. Dolores doesn't care about civil rights. Go to PC, have a shower. This is when we had no water. Bear in mind, PC showers are not ADA compliant. So it's literally tough luck, you guys. You have no water, you can't put tanks. We're not bringing any water. And we have people that are bedridden, they're on hospice, they're in wheelchairs, they're blind, and their showers are not ADA compliant. And yet we got the ready to serve bill. They were not ready to serve, they're still not. This is probably the most shocking. We complained to the CPUC and you can see it. Mr. Berry just told them, ignore the complaint, don't bother. We'll tell you if and when to respond. CPUC is an advocate agency. They're supposed to advocate for us, not for Dolores. And yet they've told Dolores right there, you can see close. They just closed our complaints, which I'm sure you got a copy of several times because I keep emailing you. So that's it. We had the 3 C's, clean, confidence. We want the 4th C, please, you guys. You keep talking about safer. Bring it on. Consolidate Dolores. Let us go somewhere else to a non-profit water organization because water is a human right and we have the right to feel safe. Thank you.
Thank you, Ms. Woods. I appreciate your time this morning coming before a public forum and advocating. Please do continue to work with the Division of Drinking Water with your concerns. I know we heard a lot this morning and just appreciate you again addressing the board. Thank you. Next, I'd like to call up, believe it's, apologies, I'll pull up my list. David Van Voorhees, who will be followed by Melissa Hathaway McKeith. And just to note, again, at public forum, sometimes folks may accidentally sign up and intend to actually comment on one of the later items, and just remind folks about that. But Mr. Van Voorhees.
And Chair Esquivel, I do not believe he's joined us on the forum.
Thank you. And let's go to Melissa Hathaway McKeith.
Okay.
Good morning. You should be invited to unmute, Ms. McKeith.
Hold on.
Yep.
I should
We can
be
hear
on
you.
mute. Can you hear me now? Good morning, Chair
Good morning.
Esquivel, and good morning. First, I would just like to say how sorry I was to learn yesterday in speaking to Courtney Tyler that Janine Townsend had passed away. She's been so enormously helpful over the years, and I had hoped she was off retired somewhere wonderful, and hopefully she is somewhere wonderful. But that's a big loss to the community and to the board, and many people actually didn't know. I'm speaking today in my individual capacity. Ordinarily, I come to you as a representative of CURE, a nonprofit that talks about the salton sea and trees. But my day job over the decades has been working on garden variety, cleanup and abatement orders, and responses to requests under 13267 on behalf of responsible parties, typically in situations involving soil and groundwater contamination, increasingly vapor intrusion. I want to first say that I strongly support the clarification of the enforcement policies of the regional board, and I very much support staff who frequently is overwhelmed, uncertain, and outgunned by all of the lawyers and consultants, and the fact that with COVID, it's been challenging for everyone. My comments, I appreciate speaking during public comment. I have a doctor's appointment later. I will try to tune in, but I wanted, and I submitted a real life example, even though your public notice deadline ended on April 28th, to try to highlight 3 areas where further clarity would help with enforcement. The first is, and the example I provided was an instance in which technically the responsible party could be facing about $1.6 million in penalties for a 339-day time period for ignoring an amended cleanup and abatement order, which would have imposed $5,000 a day. In my 30 plus years, I have never seen a cleanup and abatement order penalty enforced. And I want you to know that, because I think that there are some ways that clarifying the enforcement policy would in fact bring more revenue to the board when in fact parties are recalcitrant. Second, for a private party like myself to try to initiate enforcement, it is unclear under what circumstances you can do that. These regulations talk about the fact in the case that the regional board fails to act or is inactive. Well, staff often wants to, but they're not in a position to. So does this mean I have to request the executive director initiate enforcement and he or she declines? Does it mean I have to go to the Regional Water Quality Control Board and ask them to initiate enforcement and they decline? I cannot tell when the 30-day period begins to run for purposes of putting petitions in front of you. Further, even when staff has said, or council has said, hey, we're looking at enforcement, apparently they cannot tell us whether or not the Office of Enforcement is actually doing anything. So again, it's opaque as to when it's the Office of Enforcement, how parties can provide evidence to the Office of Enforcement one way or the other. Clarification in that area would be helpful. And then finally, I pointed out in short comments that it is unclear when the penalty begins to run. Is it the point in time there's a notice of violation? Does it revert back to the date that a cleanup and abatement order ordered work and the work wasn't done? What happens when the PRP kind of partially complies, but really doesn't, which often occurs. And again, I raise these things because when I get a cleanup and abatement order, I want to be able to look at a client and say, you really do have to comply. It's not that we have wiggle room. It's not that you can ignore things for 6 months or a year. And then the regional board will do something, and it probably will not involve a penalty. So I'll close with this. You know, for those of you who know me, I've had a seeing eye dog, many seeing eye dogs over the years. And one thing I've learned about dogs, they need very clear rules. You have to enforce those rules, or the really smart dogs will figure out a way to obey or comply at the very, very last second that they have to. And I don't know that human nature is all that different. So just to recap, and perhaps when the staff makes its presentation later, we can get some clarification on these issues. I think that the policy went a long way to expanding enforcement in other areas, like the safer areas for communities that are clearly underserved. POTW, noncompliance, I mean, really big issues that your agency has to face. But in my little corner of the world, I hope we can clarify these items. I hope we can delete footnote 10, which essentially says, hey, if it's a cleanup and abatement order, maybe it doesn't matter at all. Need some clarity there. And then I'd like to close with saying that it would be very helpful for staff to have a workshop for practicing attorneys in this area. And lastly, there's been a lot of discussion over the years about maybe the State Water Board should have a mediator to help mediate resolution to get these matters resolved sooner than later. And again, I think that if enforced, this would actually generate revenue for the State Water Board for other areas where budgets are lacking. So thank you very much for your time. Happy holidays. Thank you so much for having Zoom. It's such a wonderful opportunity for people who can't travel to Sacramento. Thank you.
Thank you, Ms. McKeith. We'll take your comments as part of item number 5 here, the water quality enforcement policy discussion. And there are a few things there I'm tempted to try to respond to, but we'll keep that as part of the discussion and try to clarify and respond to some of your points at that moment. So just thank you. I believe unless Mr. Van Voorhees was able to make it onto the platform, that wraps up our public forum, and just thank everyone for here coming before the board. And that brings us now into actual board business as well. Our first item is the board consideration of adoption of the November 7th and 8th board meeting minutes. Unless there are any amendments or adjustments or questions, entertain a motion.
Move adoption of the minutes.
Second.
Thank you both. Ms. Tyler, can you please call roll call vote?
Vice Chair Diadamo? Aye. Board Member McGuire?
Aye.
Board Member Firestone?
Aye.
Board Member Morgan?
Abstain. I was not present.
Chair Esquivel?
Aye.
Thank you.
Thank you as well. Board meeting minutes are adopted. Brings us to our item number 2, which is uncontested, and I believe still uncontested, unless anyone would like any discussion. And thank you for the good work on this. It helps what is a very important discussion that we'll certainly be having here tomorrow. Entertain a motion unless anyone would like to pull it from consent or have discussion.
I'll move to adopt item 2.
I'll second.
Thank you both. Ms. Tyler, can you please call a roll call vote?
Board Member McGuire?
Aye.
Board Member Firestone?
Aye.
Board Member Morgan?
Aye.
Vice Chair Diadamo?
Aye.
Chair Esquivel?
Aye.
Thank you.
Thank you as well. Now brings us to our informational item on current hydrologic conditions and response. And I'd like to invite up Karina Herrera to kick off the item. Or Mr. Ekdahl. Ms. Herrera. Morning. Good to see you.
Good morning. So I'm actually not quite sure on the order of these slides, so let's move on to the next.
That's always the best.
There we go. Okay, so hi, I'm Karina Hura, supervisor with the conservation team in the Office of Research Planning and Performance. And this morning, I just wanted to give all of you a very brief update on the Making Conservation a California Way of Life rulemaking. So next slide. So a refresher, the rulemaking started on August 18th of this year, and our first public comment period ended on October 17th. We received approximately 400 comment letters in addition to all of the oral comments that were made during the October 4th board workshop. So we are continuing to review comment letters, and our team is also meeting with interested parties. Staff have been holding one-on-one meetings with small suppliers serving majority disadvantaged communities to better understand potential impacts of the proposed regulation. Staff have also been conducting work group meetings with thought leaders from the water community to further discuss concerns with the draft regulation, and we'll be holding these meetings through mid-December. If all goes according to schedule, we anticipate having an updated text and a second public comment period starting sometime in February of next year. And we would then bring the regulation to the board for consideration for adoption sometime in the summer of 2024. And if adopted, the rule would become effective in January 1 of 2025. And that is it.
Thank you. I just have to acknowledge and thank all the meetings I know that are going on, a lot of discussion. I really appreciate just the process that we've initiated with folks and being incredibly open to just how we think about that rulemaking and that process. And so just thanks. I know it takes a lot of work in order to hold those meetings, to be listening, to be reflective, but I know it comes greatly at a great benefit to us in our process. So just really appreciate it. Good morning, Mr. Ekdahl.
Good morning, Chair Esquivel, members of the board. I'm Eric Ekdahl, Deputy Director for Division of Water Rights, here today to provide an update on conditions in the Scott and Shasta watersheds. Before we jump too much into those particular watersheds, just a quick note that historically we've used these hydrologic updates to provide an overview of general precipitation, conditions and weather patterns and how the water supply for the entire kind of region and state is looking. We haven't done that so far this year, largely because it's been focused on Scott and Shasta and because October and November, they are technically the rainy season, but it's usually pretty small amounts of rain and things don't pick up until December, January, February. So looking into January at future board meetings, we'll return to showing some of those cumulative precipitation figures. We won't do it for December, but in January when we return, we'll start including those and we'll have a better picture of how things are progressing. So with that quick caveat, then let's jump into Scott and Shasta. As of yesterday, flows in the Scott were 162 CFS, and note that the flow in the expired regulation was 150 CFS for December. So right now they are above that, but I'll show a slide in a minute that it shows that we only very recently went above that 150 CFS due to some precipitation. In the Shasta, flows were 150 CFS as of yesterday as well, with the flow in the expired regulation of 125. So we are above the expired regulation flows in the Shasta as well. And storage in Dwinelle Reservoir is about 9,000 acre feet as of December 1st, compared to only 2,000 acre feet this time in 2022. So again, only a year ago, we were still very, very much in drought. And it wasn't until about the middle or maybe third or fourth week of December where that parade of atmospheric rivers really began to affect the state in earnest. Next slide, please. So this shows, again, flows in the Scott River. You can see right at the would be my right, probably your right too, right around the first week of December, flows were below the 150 CFS up until a couple of days ago. You see those green bars indicating precipitation in the watershed, and that's what did in fact kick the flows up above the 150 CFS flow target. I wanted to highlight fish numbers, we do have some updated fish numbers from November 28th. I want to read my notes. In the Scott, as of November 28th, there were 1,604 returning adult Chinook salmon compared with 71 in 2022. So that's a pretty significant increase. And adult coho salmon, there were 240 as of November 28th compared with 0 this time last year. Next slide, please. In the Shasta River, you can see that the flows have pretty consistently been above the expired flow target in the expired regs, trending up a little bit and a little bit even of a blip due to the recent precipitation. Fish numbers for the Shasta adult Chinook salmon, 4,867 as of November 28th, compared to about 4,600 in 2022. So very similar numbers in those two systems. Adult coho salmon, there were 27 as of November 28th, compared with 3 last year. So again, better numbers there, pretty substantially better numbers, although 3 to 27, those aren't great numbers all the way around. It is still a substantial improvement relative to what we saw in years previous. Next slide, please. Just a note that we are in the process of considering draft emergency regulations. Those will be heard at the December 19th board meeting. Staff are evaluating some of the written and verbal comments that we received on a preliminary draft we released in early November. We're still going through those, and we do anticipate releasing a final draft regulation as part of the board agenda. That will be at least 10 days prior to the board meeting itself, and there will be additional public opportunity for comment on those draft regulations and then public comment at the board meeting as well. If the board adopts those emergency regulations, they would then be submitted to the Office of Administrative Law, and the regulations would go into effect about 10 days later. They would be in effect also for 1 year following approval by OAL. Next slide, please. And then that concludes our brief overview and just our standard ending slide of stay informed, visit our website, sign up for our email notifications.
It's an incredibly busy time, and it will be here to the end of the year. And so just appreciate here also all the work and meetings and discussions that I know are going on to be able to set up well here discussion before the board. So thank you, Mr. Ekdahl. Looking to fellow board colleagues, if there's any question or thoughts? Okay, thank you. That wraps up informational item number 3. And now brings us to item number 4, which is from our Division of Water Quality regarding memorandum of understanding with the California High-Speed Rail Authority. Give folks a moment to transition here. Good morning, good morning. I'm glad I read the abbreviated title this morning as opposed to the full title of our item.
Good morning, board chair, board members, and everyone. My name is Jessica Nadolski. I'm a senior environmental scientist supervisor with the Division of Water Quality. With me today are Assistant Deputy Director Phil Crater and Watersheds and Wetlands Section Manager Paul Han, as well as Serena Liu from the Office of Chief Counsel. Representatives from the High-Speed Rail Authority are also in attendance virtually. Today, I'll be speaking to agenda item number 4, consideration of a resolution authorizing the executive director or designee to execute a memorandum of understanding or MOU with the California High-Speed Rail Authority, referred to hereafter as the authority, to provide expedited review of rail projects, environmental technical assistance, project consultations, and coordination services. The authority seeks expedited preparation, consideration, and issuance of Clean Water Act Section 401 water quality certifications and/or waste discharge requirements for discharges of dredged or fill material to waters of the United States or waters of the state, including waters of the U.S. No other permits or authorization issued by the water boards are addressed in the MOU. Expedited permitting is necessary to ensure that the time period stipulated in the granting of federal funds for construction of the high-speed train is achieved. So here we've got our agenda. This presentation first provides a brief history of milestones in the development of the MOU that recognizes the previous MOU with the authority and adoption in April 2019 of the state wetland definition and procedures for discharges of dredged or fill material to waters of the state. Then I'll provide an overview of the proposed MOU contents and a summary of public comments received, discuss the proposed approach to analysis, the alternatives analysis requirements, and provide a final reference to the proposed MOU for consideration along with staff recommendation. Next slide, please. So a bit of background, State Water Board previously executed an MOU with the authority for dredge and fill permitting in January 2017. The initial MOU expired in December 2019. As previously noted, the state wetland definition and procedures for discharges of dredged or fill material to waters of the state, or simply procedures, were adopted by the board in April 2019. The current proposed MOU is in essence a renewal of the previous MOU, but with conforming changes to make the MOU consistent with the procedures. The proposed MOU was publicly noticed and comments were received regarding recommended consistency with the procedures and highlighting areas of concern focused on application submittal requirements related to the alternative analysis. State Water Board staff and council have coordinated with stakeholders and authority staff and council as in response to the public comments, resulting in the proposed MOU under consideration today. Next slide, please. As a quick reminder, the procedures authorize the State Water Board to enter into a written agreement with state agencies to set out alternative procedures and requirements regarding the submission and review of project applications. To qualify for this alternative, the state agency must be the California Environmental Quality Act or CEQA lead for one or more projects subject to the procedures. Therefore, alternative application methods included in the proposed MOU pertaining to submission of an alternative analysis that will be discussed over the next few slides are consistent with the procedures. Next slide, please. The proposed MOU is essentially a renewal of the prior MOU with the authority, except the maximum dollar limitation for reimbursement costs under any future interagency agreement is eliminated. The MOU expiration date is eliminated. Exhibit 1, which confirms how the procedures apply to the authority's applications, is incorporated. An expanded discussion of State Water Board's role pertaining to CEQA document and alternative analysis review is provided, and editorial changes, for example, adjusting font for consistency throughout the document. Next slide, please. State Water Board received 2 comments from private citizens with concerns for maintaining public access to navigable waters and opposition to rail as a priority consideration. Both comments are outside the scope of the proposed MOU renewal. State Water Board also received 1 comment letter from a coalition of environmental groups which outlined concerns regarding the alternative analysis, specifically recommending the MOU include the same exceptions to deferral to the U.S. Army Corps of Engineers as provided in the procedures. The MOU does not rely on the CEQA process to meet procedure alternative analysis requirements. The MOU include the same sideboards for triggering alternative analysis as are in the procedures. Next slide, please. State Water Board considered the comments received. The alternative procedures for application submittal proposed in the MOU state, first, the State Water Board shall defer to the U.S. Army Corps of Engineers determinations regarding alternatives when a Clean Water Act Section 404B1 analysis is required. And second, the State Water Board shall rely on its CEQA responsible agency authorities in lieu of a separate alternative analysis if or when a 404B1 analysis is not required. Furthermore, the alternatives analysis in the CEQA document shall be sufficiently detailed for the State Water Board to determine compliance with Section 4B1 of the procedures, which states that the permitting authority has the discretion to improve a project only if the applicant has demonstrated the following. A sequence of actions has been taken, first to avoid, then to minimize, and lastly compensate for adverse impacts that cannot be practically avoided or minimized to waters of the state. The potential impacts will not contribute to a net loss of the overall abundance, diversity, and condition of aquatic resources in a watershed or multiple watersheds when compensatory mitigation is permitted in another watershed as set forth in the procedures. The discharge of dredged or fill material will not violate water quality standards and will be consistent with all applicable water quality control plans and policies for water quality control. And the discharge of dredged or fill material will not cause or contribute to significant degradation of the waters of the state. Lastly, to the extent that the impacts are not considered in a project level 404B1 analysis, the authority shall provide a description of any steps that have been or will be taken to avoid and minimize the loss of or significant impacts to beneficial uses to waters of the state. Next slide, please. I also want to highlight that the proposed MOU states the parties, State Water Board and the authority, further recognize that the State Water Board may require during review of the permit application that the authority implement additional avoidance, minimization, and mitigation measures for the authority's approved project section pursuant to the State Water Board's authority under the Porter Cologne Water Quality Control Act and Section 401 of the Clean Water Act. Nothing in the proposed MOU negates or limits the State Water Board's authority under the Port Cologne Water Quality Control Act and Section 401 of the Clean Water Act. Also, processes related to public noticing of applications and other submittal requirements as stipulated in the proposed MOU are aligned with current practices dictated by the Water Code and procedures. Next slide, please. In closing, staff requests adoption of a proposed resolution authorizing the executive director or designee to execute a memorandum of understanding with the authority to expedite the investigation, review, and preparation of required documents related to processing authority permit applications. This concludes the staff presentation. I'd like to ask if the board chair or members have any questions at this time.
Just thank you upfront for the work I know that's gone on to ensure that here we're doing well to balance our mission and an important project we know here within the state. Looking to colleagues, if there's questions off the bat, we do have a few commenters, but Vice Chair.
Thank you. And I look forward to the comments that we'll be receiving, but I just want to better understand on the slides where you went through some of the provisions that are already in the MOU. I'm not quite getting the connection between the existing provisions that you cited and how that might respond to some of the comments that the NGO community raised.
So essentially, instead of following verbatim what's set out in the procedures, the procedures does allow for an MOU with another state agency that is a CEQA lead agency. So the High Speed Rail Authority applies there. So instead of following those procedures or the alternatives analysis steps that are outlined in the procedures, because of the long lead and the back and forth and what goes on with the CEQA documents with high speed rail, we are proposing that at the time that they come to us for permit application, that the need for an additional CEQA analysis at that point, depending on whether there's a 404B1 analysis from Corps or not, might not be the most appropriate use of time at that point. Recognize they do their CEQA documents first. We receive our permit applications way later in the process. So when we receive our applications, it's not necessarily something that we see as a benefit to have them revisit their alternatives analysis, again, under certain conditions. And we have that, we're going to rely, just like the procedures, on the 404B1 analysis for core, if that's in play. If that's not in play, then we're defaulting to the 404B1 section of the procedures that states the different things outlined there that and that I stated that the authority would have to submit to us. Does that answer your question?
I see Mr. Crater has something. Yes, thank you.
Thanks. Thank you, board members. Just want to add a bit of context going back when we were working on the consideration of the procedures themselves. The alternatives analysis was a very, very important component for the NGOs, and that's the reason for this comment here today. And I think it's just a high level, what I want to say to respond to your comment is that what we've built into the MOU starts the alternatives analysis discussion much earlier as part of the public process under CEQA. And so while it's different than our normal alternatives analysis pathway, there is a single point of comment for the public through the CEQA process. And we have all the authorities, including some that we've added to the revised document, like items A and B up there, to ensure that we can require the same pieces of the rail authority that we do during the normal alternatives analysis process. And if my colleagues want to add anything to that.
Yeah, I just think that, this is one of those situations where we're throwing around some acronyms and some euphemisms that we use in here, 404B1, et cetera. I think it would be important to just go back to what it is that is the goal of the alternatives analysis, which is to ensure that a sequence of actions has been taken to first avoid, to minimize, and lastly, compensate for adverse effects, to ensure that there's no net loss in the abundance, diversity, and condition of aquatic resources, to ensure that we won't violate water quality standards, and to ensure that there won't cause or contribute to a significant degradation of waters of the state. Those are really important goals. That doesn't necessarily mean that we have to wait till the end of the process to address those goals, and our permit typically comes at the end of the process. Embedding with high-speed rail at an earlier point in the process gives us more influence over ensuring that those goals are met. And that's why staff has been advocating for this MOU.
Thank you. I appreciate that.
Yeah, thank you, Vice Chair. I think we'll further, I'm sure, unpack as we hear comments here around, again, the ability here for us to, even though we're relying on the CEQA document, and we are at the table and ensuring that all our alternatives analysis and other considerations are being part of that, we can still add more. And there's a process for us to be able to do that if something is left out amongst it. Thank you. I appreciate it. Let's move to our commenters. And I believe our first commenter will be Ashley Overhouse, who will be followed by Lisa Belenke, and then Karen High. Should be invited to unmute. Apologies, Ms. Overhouse. There we are.
Can you hear me now?
Good morning. We
Wonderful.
can. Thank you.
Thank you, Chair. Good morning, board members and staff. First, a thank you for accepting our comments back in 2020 and giving us another opportunity to speak on this issue again today. Ashley Overhouse, Water Policy Advisor with Defenders of Wildlife. And today I'm giving my comments on behalf of Defenders and my colleagues at Audubon, California, who unfortunately couldn't be with us today. I first want to again thank your staff for reaching out to us and discussing our concerns and comments earlier this year. While we're grateful for the red line changes in the MOU as well as Attachment A, Defenders and Audubon still have concerns with the Attachment A permit requirements, specifically, of course, the alternatives analysis permit requirement that was referred to earlier, subsection 1N. Since the public commented and reviewed this MOU in 2020, I just think it's important to note some major developments that have occurred in the last 3 years that were missing from the staff presentation. The High-Speed Rail Authority CEQA documents are seemingly almost complete now, despite the project design not being finalized or near completion. And of course, as mentioned earlier, alluded to earlier, the U.S. Supreme Court Sackett decision and the new EPA regulations, which drastically narrow the definition and subsequent protections for waters of the United States, something that the board has acknowledged, and we're especially now grateful for the state wetlands policy in place. But this development does impact the protective scope of the Army Corps' 404 authority. So while we appreciate the board's willingness to update the MOU, I don't think it adequately addresses these recent developments. So first, the subsection still fails to adequately protect state waters that are also not waters of the United States, because it doesn't just directly apply the state's procedures framework. It was carefully crafted by this board and staff and stakeholders for over a decade. Instead, the subsection just still defers to the 404 authority. And after the recent Sackett decision, that is particularly concerning for our NGOs. And then most of the high-speed rails authority's project scope, of course, impacts intermittent streams and vernal pools, both of which would be considered waters of the state, recognized and valued by the state and this board as important habitats to conserve. And it's unclear if the board has a better understanding now after the Sackett decision of exactly how many waters of the state are impacted by this project, and will require additional protection and analysis that will not be covered by 404 analysis. And unfortunately, a subsection, in our opinion, still eliminates the Water Board's ability to meaningfully oversee the Corps' analysis of alternatives, and requires the board to defer to broad nationwide permits that the board has not certified. And second, the subsection 1N still relies on the board's authority as a responsible agency under CEQA, but this still undermines the standard of the state wetlands policy to avoid, minimize, and mitigate impacts I'm summarizing here. And it's a higher and more protective standard, one that relies on, as the staff mentioned, sufficiently detailed alternatives analysis. But more importantly, I feel like the subsection language sets a dangerous precedent for future projects. This is not a comment on the high-speed rail project itself, but more of the board's willingness to exempt a project of this size and scale, and the way it's going about it. And then finally, subsection 1N does not require the high-speed rail authority to update the board if the project design changes, only early consultation. And while we appreciate that early consultation, CEQA analysis is now way underway, if not almost complete. So we're concerned that the project design will still change as it's finalized in the coming years. And so it's more important than ever before for the board to retain its authority, of course, to apply the procedures framework to protect waters of the state. So that is all to say today. Defenders and Audubon request the board consider these concerns, remove subsection 1N of the MOU attachment A, and defer finalizing and approve the MOU today for execution. We are more than happy to continue to work with staff and high-speed rail authority to ensure that the procedures are just directly applied to rather than undermined by this MOU. And alternatively, if for some reason the board cannot defer to finalize this MOU today, we respectfully request that you amend subsection 1N of attachment A by adding specific language to expand the board's authority even more than the language that's already been added, in case there are future project design changes that are consistent with your authority under the state wetlands policy. So more than just applying and relying on the 401 authority to reopen, let's say, CEQA analysis after it is complete, adding specific language that'll make sure that the high-speed rail authority is required to come back to you at a future time when the project design changes. I hope that's clear. Again, our concerns have been noted and taken into account by staff. We're really grateful for this opportunity to give public a comment again. Thank you for your time.
Thank you as well, Ms. Overhouse. Appreciate your continued engagement in this. And I know however the board goes, I look forward to what is continued engagement on these important issues moving forward as well. So thank you, Ms. Overhouse. Next, I'd like to call up Lisa Blanke, who will be followed by Karen High. And we have speak as necessary, but I think last there is Ellen Weir.
Good morning, board members. Lisa Blanke, Senior Counsel with the Center for Biological Diversity. A lot of my remarks will echo the ones you've just heard, but I did want to also speak today. And I thank you for the opportunity to address this MOU for the high-speed rail project. The center, along with other groups, were involved in getting the procedures in place to protect the waters of the state. And that took over a decade. And it's very important to us that they be followed. I understand what is being put forward as far as the idea of early CEQA alternatives analysis perhaps being better than at the end when you're doing your permitting, then looking at the alternatives. That does make a lot of sense. However, as a responsible agency at the CEQA stage, you're not likely to have the kind of influence over alternatives that's really needed to protect the waters of the state. And that's an essential piece of this. The waters of the state are far broader than the 404, and that gap has just widened incredibly over the last few years with the changes in the legal structure. These waters, these often, ephemeral or seasonal streams and wetlands that don't fit within the very narrowed federal definition are critical to the state's ecosystem. And we have lost, almost 90%, I think was the last number I saw, of the wetlands in the state. These waters of the state need to be protected, and doing so simply through a CEQA process, which, as Ashley mentioned, some of it has already been gone forward, even without specific design, which simply makes no sense if you're trying to protect very specific resources on the ground. You need to know exactly where they are and how much of them there is. So one of our concerns as well is that this MOU is being entered into without any sense of what the scope is of the waters of the state that will need to be protected outside of that federal Clean Water Act 404 permitting. And we would like to see more detail on that before the board enters into the MOU. Let's see, I was going to say a few other things. I think that particularly in the attachment A and subsection 1N, it really does defer the board's authority, and relying, as I said before, on CEQA alone and the responsible agency role is not the same as undertaking the alternatives that were required under the procedures. The need to avoid, in particular, needs to be looked at, yes, early in the process, but it needs to be looked at in the way of actually imposing an avoid mandate, not just simply, oh, well, this is the easier route, or there may be many, many reasons for one route over another, and there may be impacts that cannot be avoided. But that needs to be looked at specifically with the lens of the waters of the state, and not only through the lenses that the lead agency will be using, which has a different mandate to ensure that the project goes forward. So today I would request that the board either defer this item for more consideration or remove the section 1N and apply instead the procedures for dredge and fill in waters of the state and the wetlands definition directly. Lastly, this question that was raised as far as the project design changes. The board cannot release its authority for design changes. As the design changed, they will need to come back and ensure that the permits are aligned with that and that there is an alternatives analysis. And we believe that this will be better served through the procedures than by relying on general CEQA analysis that is then tiered, and later CEQA analysis when we have all seen often the alternatives are not fully considered at later stages as the design changes. We are very concerned with the protection of the waters of the state, which provide habitat for myriad plants and animals, and they're public trust resources that should be protected for the people of the state as well as for the public trust in wildlife. So thank you for listening to my remarks today, and we hope that the board either defer this decision or remove that section 1N from the MOU. Thank you.
Thank you, Ms. Belenky. Appreciate the comments and engagement here on the item and continued on engagement on the work. Thank you. Next, I'd like to call up Karen High and then be followed by Ellen Weir.
Good morning, Chair Esquivel and members of the board. Thank you for the opportunity to provide comments. The Citizens Committee to Complete the Refuge was signatory on a joint letter submitted to the State Water Board in response to a draft MOU with High Speed Rail in 2020 and participated in a stakeholder meeting with staff earlier this year, and we appreciate the opportunity to engage. However, we're extremely disappointed that our substantive concerns have not been heeded, concerned that the proposed MOU sets a dangerous precedent and will result in differing standards of review for impacts to waters of the U.S. versus waters of the state. Our concerns lie mainly with subsection 1N, as Lisa and Ashley have already explained. CCCR was a stakeholder during the development of the state definition of wetlands and the development of the State Water Board's dredge and fill procedures over the course of more than a decade. The intent of this work was to ensure adequate protection for waters of the state in response to a reduction in the reach of the Clean Water Act. In May 2023, as we're all aware, the Sackett decision further reduced the reach of federal protection for waters, including wetlands. However, the language of the MOU does not reflect this change in the regulatory landscape and is largely as it was drafted in 2020. According to the language of the MOU, differing standards of rigor would be applied to the review of impacts to federal versus state waters. Subsection 1N states for sections requiring Core 404B1 analysis, the State Water Board shall defer to the Corps' determination on the adequacy of the alternatives analysis or the draft analysis. However, for waters that are solely waters of the State Water Board is supposed to, during the CEQA process, review and comment on the sufficiency of the authority's avoidance, minimization, and mitigation measures pursuant to Section 4B1. And of course, we all agree that the agency should weigh in earlier in the process and not just wait till the end of the process when the permit application comes in. However, by limiting or putting this restriction regarding the CEQA process, what is the CEQA review for all of the research, all of the reaches of high-speed rail? It's our understanding that the CEQA process has already been completed for most of the segments. Under the language of the MOU, how are staff to comment pursuant to Section 4B1 if the CEQA process has already been concluded? Section 1N removes the requirement that applications comply with Section 4, including Section 4B1, which is the alternatives analysis and no net loss of the procedures. This would set a dangerous precedent and does not ensure adequate protection for waters of the state, water quality, or beneficial uses. As previous speakers have requested, we urge that Section 1N be removed from the MOU or the decision deferred for more analysis. We do support the need for additional staffing to enable State Water Board staff to respond in a timely fashion to the authority's permit requests. Thank you for the opportunity to comment. We hope that we will have additional opportunities moving forward.
Definitely so. And thank you, Ms. High. Appreciate the continued engagement. Next, I'd like to call up Ellen Weir.
Good morning, Chair Esquivel and members of the board. Ellen Weir on behalf of Grassland Water District in Merced County. We have a long history of working with the High-Speed Rail Authority to address impacts of the project as it traverses our wetlands within the grassland ecological area. And we previously supported the adoption of your state wetlands policy and commented on the proposed MOU. So now these two things are coming full circle, I guess. The MOU describes how the state board will apply its wetlands policy to a very large infrastructure project. So in a way, it does set a precedent for other large state-led projects to follow, particularly with the recent rollback of federal protections for wetlands under the Clean Water Act, under the Sackett decision. This MOU is kind of a big deal for those of us wishing to protect wetlands affected by the rail project. So I'd like to support the request made by others today to either remove section 1N from attachment A, which is located in attachment A, page 4 of the MOU, or add some more protective language to that section. Section 1N deals with the alternatives analysis under the wetlands policy, which sets forth how the project can avoid or minimize or compensate for unavoidable impacts to wetlands. And I can tell you that for the section of the high-speed rail project that runs through our area, which is the San Jose to Merced section, the CEQA process has now concluded, and there will be significant unavoidable impacts to hundreds upon hundreds of acres of wetlands. What section 1N does is defer to the water board's role as a responsible agency under CEQA rather than the required alternatives analysis under the wetlands policy. So that's essentially the issue we're concerned about. And the reason we're concerned is that the CEQA documents for the various project sections here are very big, they're very broad, and they essentially defer to future wetland delineations, future mitigation planning, and future permits for wetland impact avoidance. Essentially, they can see that those analyses will mostly happen later as the project design is advanced. So it's kind of a chicken and an egg issue regarding how the water board can meaningfully engage. And because of this, we don't believe CEQA is adequate as the only channel for the public to address how wetland impacts from this project will be minimized. There's a number of items, for example, that remain unresolved with high-speed rail right now, even after CEQA is complete. And those include alternative options for the timing of construction, particularly in our seasonal wetlands, where there could be significant alternative approaches that the rail authority could take to avoid wetland impacts. So we just want the opportunity to take a deeper dive, or for the water board to have that opportunity as part of its permitting process. In trying to respond to our concerns, staff did add language in section 1A stating that the water board may require additional avoidance, mitigation, and minimization measures, but we're really not sure how that will happen if you're deferring to your responsible agency role under CEQA, and CEQA is now complete. Also, in reality, the rail authority has developed a pattern of making major changes to its project design as the project moves forward. You know, the footprint can change and has in other project sections. So we're asking you, if you are unwilling to remove section 1N and simply require the wetlands policy alternative analysis to go forward as written, if you could at least consider directing staff to add more language to section 1N, language that speaks to the issues and preserves your ability to make sure the wetlands policy authorities are preserved. Some language that I would suggest is that the authority shall notify and consult with the water board as the project section design advances, including any changes that significantly impact waters of the state or any mitigation plans or agreements related to wetland avoidance and mitigation. Thank you for allowing these comments.
Thank you as well, Ms. Weir. Appreciate everyone's good engagement on this, and here trying to really listen to the concern and really, you know, for me, I think it is, you know, are we closing any doors when it comes to our ability to ensure that, to, you know, the concern of what we heard today is, you know, the continued protection of wetlands. This is a significant project. You know, I think it's really a matter perhaps here, and I'll let folks here better respond, but of kind of the, you know, belts and suspenders sort of way one might view, you know, our continued ability to ensure that any impact is mitigated, accounted for, analyzed, and appropriately part of the authority's consideration. So how are folks feeling on, I guess, again, the ability for the board to continue to engage, knowing that this is a project that will have, I'm sure, continued adjustment as it kind of unfolds?
Thanks. I thought it would be helpful just to provide a little bit of clarity. I noticed for some of the comments, there seemed to be some confusion about what the MOU would do and what aspects are affected by the MOU. So first, I wanted to talk about the Sackett decision. So even prior to Sackett, there were some non-federal waters of the state that were going to be affected by high-speed rail. So Sackett will increase the number of wetlands that are wetlands and other waters that are non-federal. But it was not an issue that was not contemplated under the prior MOU. It will mean that in more instances, potentially waters will rely on the waters of the state process. But I wanted to make sure that was clear. And then where the Corps is not conducting an alternatives analysis or where the Corps is not permitting the project, nothing in the MOU says that we're giving up or abdicating our authority. The Water Board will permit the project. If the Corps is not there, that, just consistent with the procedures, the application and review process should look the same and the standards would be the same. So I just want to be very clear. Like, for example, the wetland definition came up. The wetland definition stands. This MOU does not affect that in any way. This is just about how we receive the information. And the MOU is not proposing to change review standards either. So ultimately, the review standards are set forth in Section 4B of the procedures. And those are the same, regardless of whether it's high-speed rail or any other discharger. The other thing that I think would be helpful to clarify is I want to make it clear that that CEQA is not the only touch point. So when we talked about revisions that staff proposed to the MOU that would help make that clear, there are 2 points. Ellen Weir referred to one of them, that during the application process, we can still require additional avoidance, minimization, and mitigation. And that's precisely to address some of the issues that they were talking about, that at the CEQA stage, sometimes the project design is not finalized. High-speed rail will still need to submit an application to us, identifying the impacts. This is not a deference to the entire CEQA process such that they submit their CEQA review and then they never have to come to us. They still have to follow the normal application process where they tell us exactly where the impacts are. And if there were updates to the project design, they would also need to give that information to the water boards. And the second place where we made the revision was also with respect to nationwide permits, just to make it clear that even for nationwide permits, we can, the state water board can still require additional avoidance, minimization, and mitigation measures. So I think that's the context I wanted to give.
Yeah, I'm going to talk about it a little bit from the practical aspect. First of all, I want to emphasize that I don't think we have a disagreement with the environmental NGOs about the goals that we're trying to reach. We agree that the goals of the alternatives analysis are important and that they should be addressed. We simply disagree that the procedures that staff developed and the dredger fill procedures are the best way to address those goals in this particular case. So just on a practical basis, the environmental concerns kind of appear to fall into 2 bins, one of which is choosing the correct alignment. And the second one is making sure that the construction is done in a way that minimizes impact. I think those are laudable goals. I think those are reasonable concerns. But regarding the alignment for a project of this size, it would be extremely difficult for us to revisit the alignment as part of the 401 certification application process. In fact, CEQA is a much more appropriate time for us to engage there. And in fact, I would say that our engagement with the CEQA process is an example of how this process is working. Recently, within the last 6 months, we had some coordination with one of our regions about one of the southern alignments. And we did work with high-speed rail about alignments as they relate to wetlands and waters of the state protection. But what we found through that work was that the primary issue wasn't really wetland protection, but avoidance of some critical hazardous material sites. That issue would not have come up through our 401 process. That only came about because we were embedded with high-speed rail at a time that was early enough for us to do coordination with the regional boards. So I would like to suggest that CEQA not only meets our 401 requirements, but serves to meet bigger goals for the water boards. With regards to that second bin of how do we actually construct this project in the most environmentally protective way, I want to echo what Serena said, which is we still do have the ability to write the permit. We are still writing a 401 certification, and that is the appropriate place to deal with those types of construction issues at a point where the development is far enough along for us to know what the actual plans are. So I think the NGOs are correct that there's a lot that isn't known at the CEQA stage, but we are working with high-speed rail in a way that allows us that progressive elaboration and allows us to address different points at where we have maximum influence. And so again, I think that the MOU requires the high-speed rail and the board to meet the 401B1 goals of an alternatives analysis. We're just doing it in an administratively different way.
Really appreciate that. Vice Chair and then Board Member Firestone.
I just would like to follow up on and thank you for that explanation, but on the alignment issue. So I think I'm hearing you say that on the alignment, this is it's more effective through the CEQA process, but I'm hearkening back to a comment that Ms. Weir made about any changes. And then Ms. Liu, I think you had said that would be part of the process. So can you just clarify that? How would we post-analysis learn of alignment changes? And then how would that feed into this coordinated review that you're talking about?
So when I said changes before, I was really alluding to the construction changes that Paul was talking about, the actual project design, once they have more details. If there was a change to the alignment, it would be likely that the CEQA document would need to be revised. So did that answer your question?
Yeah, but then maybe I misunderstood Ms. Weir. I'm wanting to make sure that her concern is addressed in terms of our ability to analyze in the event that there are significant changes. So I guess I misunderstood. I thought it was alignment, but maybe it's construction.
So let me give a try, and Serena, jump in if I'm too simplifying. But at the early stages, they have a conceptual alignment, and as part of the CEQA document, we work with them on that alignment. As they move forward and do more detailed analysis and refine this exact alignment, they still have to work with us to meet the goals of avoidance, mitigation, minimization, and then mitigation compensation. So they really are in two different bins, and under the alignment bin, Serena's correct. They would do an amendment to the CEQA document for the alignment changes or a special addendum. Or, there's all sorts of different pieces of that puzzle, but they're coordinating with us through that process. I would like to emphasize that one of the issues that we'll always have with high-speed rail is that water quality is only one piece of an alignment decision, and it's not going to be the only piece of the alignment decision. And so as they're making those decisions and weighing all of those pieces, we're working with them, but in the end, we're working towards avoidance, minimization, and mitigation where it can't be avoided because there are other reasons why the alignment's there. So there are those two different pieces. I hope that helped.
Vice Chair, Board Member.
Yeah, and I'd just like to delve a little bit more into that. That was super helpful. But maybe if we could ask the commenters on this, are there examples of things
that would be considered in an alternative analysis that you don't think are in the scope of what would be considered in the permitting, minimization, and mitigation avoidance. So is there, just like to understand if there's examples. I think we talked about alignment, but are there other things or examples that you think are going to be not considered in practice if we're doing it this way?
Yeah, and perhaps if there's anyone on staff that can think of something, and if not, anyone on the platform, just raise your hand and I can call you up if you have some examples for the board member.
Can I just add while you're looking for hands that, part of this is because it is such a long process. I mean, the alternatives analysis really is a focus at the CEQA stage when there's almost no design. I mean, don't quote me on the numbers for rail, but it's not even 10%, I think. It's really at that starting stage. And as everyone has said here, if they do have changes at that point, which can come up because of comments we've made or from other entities as they go out and do public noticing, they do go through addendums, and then we get to look and see at their different CEQA process. As they develop design and, are going out and doing things like delineation, absolutely, they start refining, and we continue to work with them in that process. And as they have changes, we continue to comment on those changes. Then they finally come to us for application or with an application. We'll review all of, the timing, the impacts, the where, and can comment and condition and do comment and condition, all of that piece. Once we go to, post permit, if there's still changes past that, there is an addendum process and or deviation process if there's minor amendments that rail has to come and report all of those changes to us too, and we have to approve them prior to rail doing them. So it really is a stepped process all the way where we are working in a partnership with them to try and be protective of the resources and beneficial uses. So
We appreciate that, Ms. Nadolski. Ms. Weir, please.
Yeah, thank you for the opportunity to revisit this issue about alternatives analysis under CEQA versus alternatives analysis under the wetlands policy. I think that's really the question here, is that they're different. And at this stage, the Rail Authority's alternatives analysis is, pretty broad, and it's dealing with alignment and things like that. But the point we're trying to make is that if you cede your authority under the alternatives analysis for the wetland policy, all you really have left is a vague promise that you could impose more mitigation and a review of their mitigation plan for simply offsetting or purchasing other lands elsewhere to avoid their impacts on wetlands. So examples of things that I think could come up under the wetlands policy that could be strengthened in section 1N are the timing. I gave an example of the timing of construction. Could the sections of rail that are proposed to be constructed through wetlands, particularly seasonal wetlands, be constructed at a time of year that avoids when water is out on that landscape, when birds are in the landscape, when there will be significant impacts to those wetlands? Could there be other things like pile driving or nighttime construction, or things that you could look at to try and reduce and avoid the impact on those otherwise unavoidable impacts to wetlands? So I just wanted to emphasize that point. It's not necessarily just about alignment or changes to the project that would require a new or revised CEQA document. It's also just those individual mitigation plans that still have yet to transpire for large sections of the project.
I've got it. Appreciate that, Ms. Weir. And a follow-up from Vice Chair before response.
Thank you. I'm just wanting to make sure that I understand we're not ceding our authority under this MOU in any way. And so, Ms. Weir, even though I completely agree with you, I actually worked on high-speed rail for a bit, so I totally understand that project moves and shifts just because of the challenges of, alignment issues. But I don't think that we could contemplate all those different scenarios here within this MOU. And I'm not concerned if, as long as we're not tinkering with the procedures that we spent a lot of time on. So getting back to my earlier question about an analysis for, any new information or change, is there a public process when you receive that information? I think you were very clear that you are undertaking additional analysis, but what are the potential touch points for the public in the event of these changes?
If you're talking about the alignment changes at the initial stage, I mean, if the CEQA documents are going through addendums and all of that, it's going through full, the CEQA process. So there's multiple public outreaches in addition to, coming to the different agencies, both federal and state, and working with us as well. So, in that CEQA forum, because those changes are being made or added to, if you will, to CEQA documents, there's public outreach under that CEQA umbrella.
What about after CEQA?
Any late changes that we make through the evolution of the permit would be available to the public when we notice the permit, the draft permit. And so they'll see all that, and there's an opportunity to comment at that point. And I just want to add that, throughout the process, we have excellent communication with the high-speed rail, and I think it's because of this MOU, not in spite of it. And so I really do want to give a plug to the collaboration that we get from the authority working with us the whole way through. I understand why there are concerns here, but this does all make its way out to the public. Serena?
If I could just add a little bit of detail, especially because the concern here is non-federal waters of the state. So for that, the public notices of the draft order. And so that would be, the public would have an opportunity to look at the kind of details that Ms. Weir was flagging.
Right, it's that moment of the permit that we, the sort of protections around construction, time of construction, the sorts of mitigation or minimization of impacts would be there. And our authority to ensure that they're there is not given up by this MOU here, importantly, in this moment.
Could I ask staff a question? The commenter mentioned the idea of inserting in one end language that requires high-speed rail to consult with the board and any changes. I think that's implicit in the document, but does that cause any concern? I know that this is an MOU and it's an agreement, not a permit that we issue, but would that be a concern with the high-speed rail or with staff on, do we need to, consider it?
So I agree, it is implicit. From program perspective, we do not have a concern with that. I'll ask legal if there's any legal concerns. Beyond that, we do have the rail authority available as well, so we could ask them directly if they have any concerns.
And John, I believe that language is in there, but I want to skim through it real quick and find exactly where it is so that we can have a meaningful discussion about whether that language is sufficient.
And maybe while you're doing that, can I just follow up on, so the example of seasonal construction or, pile drilling, maybe even the design of the, so it may not be exactly alignment, but maybe some of the design of the rail infrastructure, that's the word I'm looking for. If there are specifics, since that's not all fully developed, and I understand on construction, what I'm hearing is we can do some avoidance, but can you just speak to those examples that were given as to whether we still are going to be, whether that's in the scope of what will be considered as we implement our permitting process from the avoidance, minimization, mitigation standpoint, rather than needing an alternatives analysis.
So I can let Jessica have the opportunity if she'd like to add any more detail, but I think the issue is just of timing. So the CEQA process would be complete. And then, and I think the high-speed rail, it frequently engages in pre-application meeting with us so that we do have information as this develops. But most of that information would be in the project application itself. Because that's the stage in which they are formally applying to the water boards with the level of detail that I think the commenters are really interested in. So the timing of the project, the exact location, the delineations of the affected water bodies, their proposals for restoring temporary impacts, their proposals for mitigating for permanent impacts. That level of detail comes at the project stage. And so it depends on the kind of, I was not, in terms of getting updates from the rail, I wasn't sure what stage we're talking about. I don't think there would be opposition to continued engagement and collaboration because I think that helps both agencies. But certainly if they have post-application changes, they would need to notify the water board, just like any other applicant would need to notify the water board if their project changed, including, the season in which they're working or the exact kind of construction that they're undertaking.
Yeah, I would just add that, during that application phase too, we don't look at rail different from any other applicant, meaning, the information they provide is vetted through a completeness process. We're asking questions, they're providing more info. We send that information to our regional boards for them, that are impacted, for them to look at and offer any comments or concerns that they have too that we can work out before we go to permit. We're also, looking at either the applications or the full-on permits from other agencies, because I know wildlife was brought up, which may or may not be in our purview, depending on whether it's waters related. But, we're looking at those things to make sure that what we're conditioning is appropriate for the amount of impact for the project. I can also say that to date, the authority, knowing that they do, tend to need design minor changes as they build, their assessment area is a lot wider than what their actual construction is. So they're essentially permitting impacts for a much broader, section of land or straight linear piece of land than is in actuality going to be needed, with the idea that if, during construction, they get to a spot, it's like, oh my goodness, we need to put in an extra pier here, and that's going to be more impacts. They report it beforehand, we look at it, we, discuss it, can approve it. But at the end of the day, they're planning with us for those types of consultations. And at some point they do need to, step back and work on their design without us, but they very much engage us pre and post their CEQA process up to receiving an application on our end, because it's a no surprise scenario.
Right. Yeah, and that's all really helpful. I think the piece I'm still not super clear on is, so what I heard from the commenters was there was concern about that really what we would have is approval authority and ability to for permits that really go to mitigation. And I'm just that what's missing, what I heard is what's missing is the alternatives analysis component of the procedures at the project level. So I'm still not super clear from staff. Is there an alternative? Like, is there scope difference in terms of what we would be able to consider at a project level through the permitting process in terms of alternatives than if we're approaching it this way rather than what we would normally do?
So I'm going to look to my colleagues here for support, but I'll start off by saying that the examples that were provided by Grasslands Water District are all things that are within our ability to condition at the construction phase. So I do not believe that there is any difference in the types of things that we could require under the alternatives analysis versus the CEQA MOU that we're using. Serena?
Just something that Ellen brought up that I think is useful, that we agree with, which is, and we made this argument when we were developing the dredger fill procedures, is that at its base, the CEQA alternatives analysis is slightly different from what's intended for the alternatives analysis for the 401 certification process. Ellen's correct in flagging that, and that's one of the reasons why we have this MOU. Our procedures reflect that, and one of the things that they say is that we encourage applicants to combine the alternatives analysis and the CEQA analysis. We recognized at the time that that was possible and beneficial to do. So while I agree with her that those the outcomes of those analyses are slightly different, that's one of the reasons why we have this MOU, is to explicitly say, hey, we want to use the CEQA process to meet those 404B1 requirements. I want to invite Jessica to talk about how this progressive elaboration and this coordination with high-speed rail has happened through one particular part of the project. And Jessica, please.
Yeah, and I think part of this might be a naming convention. When we're talking about project specifics, we really, in the trenches here, put that underneath the accurate project description, and more so calling it an alternative, but it really is an alternative. So it's might be a slight naming issue. But we do look at all of those things, like the timing and the actual project description, into what Paul was talking about. At one point, for one of the sections that is constructed already, the original proposal was 2 or 3 different piers through one of the rivers in the Central Valley. And, upon looking at that, we had discussions of, do you actually need 3 piers? I mean, of course, safety and all that rolls into play, but can you reduce those? Can you span? Can you do other things? And, at the end of the day, they did actually take away one of the piers and reduce. And we've had those kinds of conversations where there's, smaller crossings of, is it possible to span instead of, just dropping a pier? And a lot of those conversations need to happen when they're out there with the contractor. And so a lot of the changes along the way have actually been in the benefit side of the aquatic resource, because we are having those, timing considerations. I mean, frankly, this year being post the atmospheric rivers of last year, a lot of the areas that they anticipated to be dry during their construction season ended up being wet, as you likely know, in the valley. So, we got a lot of requests of, hey, what do we do here? Can we dewater? Can we add conditions to this to be able to work in this scenario and keep the Wirral project growing? So we have a consistent dialogue with them back and forth to, again, try and be protective of the resources. But those specific things that were brought up, like timing and, again, my bridge example, are absolutely discussed in my realm, more in the header of a project description, but it's, can be looked at as an alternative too.
Appreciate that, board member. I guess it comes back to the question, if there is some language out there that, again, better makes clear the intent, or if we feel the language is strong enough as it is, or can be identified, and importantly, I think we should hear in response, but that the board isn't, again, giving up any authority here, and the work and, importantly, spirit and outcomes from alternative analyses are being captured, and for that isn't in the process within CEQA, whatever doesn't best sort of fall in or have alignment, we have sort of a catch to be able to, and I hear, again, the concern that once CEQA is completed, what is then our ability or authority, and that extends through the actual permit here. So I think that that's important too. But I think, I think we want to set the right balance. I know there's concern about setting precedent, and then I think that that's where we do want to be clear that, the precedent here isn't waiving and or otherwise having net harm to wetlands, but instead, and important to note, again, the wetlands policy itself anticipated just this discussion around it, and especially alignment around CEQA and the alternatives analysis, instead of doing a 2-part dance, moving it up further into and making it be able to complete the intentions of what the alternatives analysis was. So, on the question of language, I don't know how the board itself is feeling, but I don't know if there's any proposal for anything that might be more belts and suspenders.
I think I'm looking for staff's input on this. I think Mr. Hahn was looking to see if the language is already captured in there somewhere. So I was waiting to hear a response to that.
So one of the things we were looking at is what does the existing MOU or the proposed MOU say about early coordination? And I did want to flag that on page 5, and so not, we've been talking exclusively about attachment 1N, attachment A 1N, but so in the main body of the MOU, we added language after talking with the NGOs to the CEQA and project consultation section that directed the authority will request early coordination with the State Water Board prior to the submittal of the application. And I think that that would be where we would view the opportunity to have early discussions prior to the submission of an application with, nailed down details about the specifics for additional opportunities to provide them with input on avoidance, minimization, and mitigation impacts.
So I think the question is clarifying, if it's not in the MOU, that changes that happen after the CEQA analysis is complete are brought to the regional board as part of their review for avoidance, minimization, and mitigation. And not sure, I understood that to be that concern that may slip between those cracks.
We can certainly entertain language if the board desires. I don't think the language that was proposed would cause us any problems.
Yeah, we do have, I believe, someone from High Speed Rail, and I know it's hard sometimes when, we're here at the dais, but if there is any, don't feel the need to have to respond, but if there is any, just reflection on the comfort of that language, it'd be helpful. But anything from other board members kind of help us feel where we are?
Yeah, I'd be comfortable, but maybe if we take 5 minutes or whatever you think, so that we could actually see the language.
And our colleague from High Speed Rail, if you'd like to speak, feel free, or if you'd like a few minutes as well and everyone can confer, that works for us as well. Let's take a break and come back. How long would be helpful, Mr. Prater?
May we have 10 minutes?
We'll give 15.
15 is great. That's great. Thanks.
Let's go ahead and come back here at 11:05. Right. Thank you, everyone. Appreciate it.
She wants to make a point.
Right, I'm like, one day I will be out of bed. He's sort of all that kind of like, mess with the stomach breathing and he's not sleeping, but no. I'm not. Like, basically, very, and then it's just, you know, things, but yesterday, that's it. So, yeah. No, it's okay. My husband's on board. He's fine. Really starts like another areas. To the people on the coast, and they're on the coast, he lives in mine. So we're going on right together. So we're looking up now. And like, this here, this right. On community line.
All right, we're at 11:12. Appreciate everyone and the time I know folks took to go back. Who would like to present?
I will kick it off to start with and
Mr.
then
Bishop.
turn it over to Michael. So we did go back and discuss, and we had a chance to talk to the High Speed Rail Authority during that, and they will come on in a minute and speak for themselves. But we actually both agree that the MOU already includes the kind of reassurance, but it may need some clarity. And so we have a proposal for, instead of trying to change this today, changing the resolution to allow us to make those kind of modifications under delegation from you all, and Michael will read that.
Thank you very much, Mr. Bishop. And I will go ahead and put some language up on the screen so that folks can follow along. But I do want to do a brief moment of table setting for the board, because this is a little bit different than your typical regulatory scene. We do have a memorandum of agreement, which is essentially a contract between two parties, and we need to make sure both parties are comfortable ultimately signing it. At the same time, there's a lot of effort that's been put into this. The comments from the conservation organizations today, I think, were very helpful to focus where they perceive ongoing concerns. As Mr. Bishop indicated, in our brief conversation with High Speed Rail, and conceptually, we all feel like it's more in the realm of comfort language, and it's something we think we could close out, but also don't think it's necessary to bring it back to the board to go through a whole nother public board session. So what I have up before you, and you can probably ignore the helpful suggestions from Microsoft Word, is essentially a change sheet, an updated change sheet that would just refine the resolved clauses, essentially giving the authority to the executive director to enter into this MOU, but create the space for changes to be made to address the concerns that came up today. And specifically, not all the concerns raised by the public commenters, there's a lot of overlap, but the board members, in particular, members Diadamo and Firestone, identified a couple of concerns about clarity and notice, as well as the chair, and to ensure that our staff were aware of the changes and refinements to the project as it moved forward. And so rather than talking about addressing all the concerns that came up, it'd be the concerns that were identified by the board members. So the way that this would carry out in terms of an updated resolution is there's currently one resolved clause. That existing resolved clause would be enumerated as one. And then it would pick up with the existing language, authorizes the executive director to execute the memorandum of understanding, and then comma, and then insert in substantially the same form as, and then pick up with the existing attachment A to this resolution, and then insert new language, but that addresses to the satisfaction of the executive director concerns about clarity and project refinement that were identified by board members during the December 5 board meeting, and then pick up with the existing remainder of the resolution. And then there would be a new resolved 2 that directs the executive director to report back to the board in a subsequent executive director's report. And those would be the only changes. That creates the space for the changes and, an arm's length negotiation with High Speed Rail. Like I said, and like Mr. Bishop said, based on our conversations with High Speed Rail, and they're prepared to join during this, we think this is an easy thing to do, but both sides need to feel comfortable with the language, and we want to make sure we're tying it back to the right provisions of the MOU.
I think that's all fair and appropriate, but do look to my fellow board colleagues for concern.
Yeah, I feel comfortable with that. And I'll just say before we move forward, well, I appreciate all the work on this. I think, the intent here, and it sounds like how it's already been progressing is what everyone would want. And it's a step forward in that. And I also appreciate the stakeholders and commenters bringing up concerns. I think we all, as staff said, are we all put a lot of time and thought into the procedures, and we all really care about wetlands and are trying to figure out how to make it work. And we are concerned about, certainly I am concerned about precedent. And so I do want to make clear that this to me seems like a really unique circumstance, is not something that I would expect us to do on a regular basis. And I also just appreciate that, you know, despite all of the intent and whatever clarity language, I think we're all coming into this. And if there are issues that arise during this, that I really encourage, you know, stakeholders, commenters, to raise things with staff, and also just encourage staff to feel like they do have the authority to ensure that we're, you know, doing all of the protections that we have in the wetlands policy and procedures that we have, which I know is everyone's intent, but just wanted to emphasize that. But I do feel comfortable. I don't know, others.
Thank you, Board Member Morgan. And want to know, apologize, went to a break before hearing your input here as well before staff began writing, but thank you, Board Member.
Thank you. So I'm also comfortable and just want to say, looking at this process, especially for a large project like this, the MOU I see as beneficial. The way I'm understanding the way, the reasoning for it and the way this here would work, and please staff correct me if I'm incorrect on this, is that this is providing you the opportunity to get ahead of the alternatives before they're already formed and submitted, where it's too late for you to then go back and to have that feedback into the process. And so it allows you to sit down at the table with high-speed rail to have input into alternatives so that there are less, you're minimizing the adverse impacts to water quality, and you're having input so that when you do get the formed project, you've already had input. And so therefore you're there at the table asking those questions and saying, can there be less peers? Can there be, are there other alternatives? Here's where you're seeing there may be some impacts that may not have occurred to high-speed rail. And so therefore you have a better informed project and alternatives when it does come to you. And then when it does come to you, we still have all of our authorities. Everything is still there. It proceeds as it would normally proceed through our process. And so we're not giving up anything. I see this as gaining something and having further input into a process so that we have a better project at the end of the day. So for large projects, I think this is, something to consider. And please correct me if I have, misunderstood the purpose of this. And then as you move forward, definitely, you continue to do what we do. And I see the clarifying language, to be helpful. So therefore, others, so that we all are on the same page and we all understand what the purpose of the MOU is, in that the Water Board is not giving up something, but rather gaining something within the process.
Thank you, Board Member. And if that's not the case at all, staff should just chime in, but that's completely what I also understand it to be. So thank you, Board Member.
Yes, I agree with all that.
Thank you, Mr. Crater.
I'd be prepared. Oh, go ahead.
Before we do a motion, I would like to give high-speed rail an opportunity to provide comment.
Yes, invite our colleague, Mr. Mori.
Oh, no. You should introduce. Yeah, hello. This is Stefan Galvez with the High Speed Rail Authority. Can you hear me?
We can. Thank you. Thank you for joining us. And thank you for the input again as we went to break and are balancing here this MOU.
Yeah, no, thank you so much, Chairperson Escobar, members of the board, members of the staff, the authority. Really appreciates all the hard work that has been taking place over the last few years to come up with this MOU. Also want to thank the comments from the stakeholders. I think that it provided a good dialogue and discussion to make this even stronger, even though we believe that this MOU already affords sufficient protections for your responsible areas as in the Water Board. We are in agreement with the language changes But we also wanted to highlight that the authority will continue and it already has in place many checkpoints and procedures that allows for that interaction. Certainly, the alternatives analysis is a key point for CEQA. That is the appropriate place for that aspect of the project. As we go to permitting, there are opportunities to add additional requirements. And this is something that it does take place in a routine manner. So again, I don't believe that you are providing or ceding your authority through this MOU. So we're okay with the language proposed, and we'll be working with staff. Thank you so much for your support.
Thank you as well, Mr. Mori. I appreciate the engagement here and continued work around, I know it's an important project and really important mission here before the board. And, and really appreciate as well the advocates that are continuing to watch and ensure that we continue to expand the amount of wetlands within this state. And, I'm very trustful that we can continue to work through these issues all together. So really appreciate the work that
I'm sorry.
has gone on with this language. Oh yes, Mr. Mori.
Yeah,
please.
just for the record, I'm Stefan Galvez Abadia.
Oh, apologies.
And I'm the Director of Environmental Services for the authority. Just for
apologies.
No problem.
Thank you for that. You're mislabeled on the system. So here, thank you. Apologize for that.
Thank you.
Okay, I'd be prepared to make a motion, but just first had a question regarding the executive director's report. And I don't think that we need to have a deadline in there, but just about how much time should we expect before we'd hear back?
Let's give it a couple of months so that we're going into the holidays. As I said, we all believe that it's pretty straightforward, but when you change language, it has to go back and forth through everybody's legal counsel before. And so that may take a little while. So let's assume that you'll hear back before March.
Sounds good. So with that, I make a motion on item number 4 with I don't know if we're calling it a change sheet or changes read into the record.
Changes read into the record.
By Mr. Laffer. Thank you.
I'll second.
Thank you both. Ms. Tyler, can you please call the roll call vote?
Vice Chair Diadamo.
Aye.
Board Member Morgan.
Aye.
Board Member McGuire.
Aye.
Board Member Firestone.
Aye.
Chair Esquivel.
Aye.
Thank you.
Thank you as well. Item is adopted and appreciate everyone's good work. Look forward to, I know what is going to be just a lot more working conversation on that project. So thank you. Next, let's go ahead, since we did take about a 15-minute break to help accommodate, let's go ahead and move on to item number 5. And it'll allow us to get to some lunch here before the last item of the day. Barring board member reports and executive director's report. Good morning, still yet, Ms. West?
Good
Mr.
morning,
Blaze.
Chair Esquivel.
Thank you both.
Vice Chair Diadamo, members of the board. My name is Yvonne West. I'm the Director of the State Water Board's Office of Enforcement. With me today, I have David Boyers, our Assistant Chief Counsel, Catherine Hall, an attorney in our Regional Board Legal Unit, and Brian Elder, our Supervising WRC and Section Manager for our Investigations and Technical Assistance Unit. I'm hoping we have there we go. Okay, just wanted to make sure it was up. We're here today to present our proposed updates to the water quality enforcement policy. First, I am going to give you a few background slides concerning our enforcement data from the last 5 years. And then I'll provide you an overview of our outreach, public notice, and stakeholder engagement process leading up to today, where we're here with more recent changes to the policy. Mr. David Boyers here is going to highlight some of those more substantive changes from the policy, and then we'll be available to answer any questions or respond to any public comments after the presentation. So thank you for your time today. If we could go to the next slide. So here, I just wanted to provide some background information about our enforcement program. These are water quality enforcement actions across our programs in these most recent 5 years from our enforcement reports that we publish on the website. Here we can see the breakdown of the different types of enforcement actions. You'll see that our totals for each year, it's not a huge range of the number of enforcement actions we bring. This includes both informal and formal enforcement. We have in here compliance actions as well. So starting with informal actions at the bottom, compliance actions next, and then penalty actions are the top yellow bar. And I think these charts accurately reflect our progressive enforcement approach. If we can go to the next slide. This is just a fiscal breakdown of liability that we've imposed across our water quality programs. This data includes stormwater, waste discharge reports, and MPDS related enforcement. Here, the chart, the bar graph is broken into different sections based on cash liability being the bottom, blue, and then we have supplemental environmental projects, which is that green bar that you see. A lighter blue, which is the enhanced compliance actions, and at the very top, compliance actions. And those are the various types of liability imposed through our formal enforcement actions. There's quite a spike in 2020. We had a number of really big liability cases there. We had a number of stormwater cases in the regions, as well as a large SSO spill that settled that year. I did want to mention that out of these projects, I wanted to mention that a number of the projects were for SEPs with environmental justice communities and disadvantaged communities. We have seen a little bit of a raise. This statistic isn't on the slide, but in putting this data together, we did note that in the mid-year for 2023, we saw a market increase in the number of our SEP funds going to EJ and DAC communities. So if we looked at supplemental environmental projects from 2018 to 2022 with EJ and disadvantaged community benefactors, and we saw about 24% of our SEP funds were going to those communities. And then we looked at our 2023 data, and so far in 2023, on the mid-year point, we have 7 supplemental environmental projects, 4 of which are identified as EJ disadvantaged community, and 89% of the total supplemental environmental project funds going to those environmental justice and disadvantaged communities. So that was a market increase, and we're hoping to continue that trend. Going on to the next slide, here are just some of the highlights of some of those supplemental environmental projects that came out of formal enforcement actions going to environmental justice and disadvantaged communities. Just provided those there for reference and just a little background. And again, those are over the last few years. With that highlight, I'm going to move on to our water quality enforcement policy. So next slide. As the name suggests, our water quality enforcement policy addresses the enforcement components of our water quality regulatory framework. The stated goal of the policy is to protect and enhance the quality of waters of the state by defining an enforcement process that addresses water quality problems in the most fair, efficient, effective, and consistent manner. And with those goals, we look to update our policy here today. If we go to the next slide, the policy terms itself require us to take a look at the policy in every 5 years and revise it as necessary. Our last review of this policy was adopted in 2017, and the Office of Enforcement began working with both the Office of Chief Counsel and the regional boards in close coordination in 2021 to identify areas that could use improvement in the policy, and those are what we're bringing before you today. Next slide, please. Overview of the original proposed changes. These are changes that went out in the original draft of the policy back at the beginning of this process in 2023, in February of 2023, we sought to reorganize and improve the efficiency and flow of the policy, clarify certain principles, and enhance transparency and consistency throughout the policy. We add categorizations of changes in the appendix of the policy. This is what we'll be talking about a little bit later. This is where we provide very transparent direction as to what types of changes can take effect immediately, which types of changes are procedural, and which types of changes are more substantive and need to be only applied going forward through the policy. We also have added template hearing procedures and a few non-substantive amendments to increase just the flow and how easy and comprehensive the understanding, the ability to understand the policy and the intent behind it. So going to the next slide. Again, this process started in February of 2023 when we published a notice of those proposed general revisions that I just overviewed. We had a public hearing here before this board in April, and then we provided a public comment period, which closed at the end of April on those original changes. Going to the next slide. After we closed that public comment period, or during that public comment period, I should say, we conducted for the first time for this policy, the AB 2108 requirements, which was the coordination and outreach to tribal, environmental justice, and disadvantaged community stakeholders. We presented the proposed changes to a number of IVAN networks throughout the state, as well as providing email notifications to our tribal, EJ, and disadvantaged community lists of contacts that we had, working in coordination with our Office of Public Participation. After the comment period ended, we found ourselves with 10 comment letters. We conducted a number of stakeholder meetings with stakeholders such as the California Coast Keepers Alliance and the California Association of Sanitation Agencies. And on the November 20th, we published our response to comments and our proposed final revisions. We've had a couple of change sheets as well that are incorporated into the record, and they're referenced on the agenda. And with that, I'm going to go ahead and turn the presentation over to David Boyers, and he's going to provide a more detailed overview of some of the comments received and more recent changes to the policy in response to those comments that we're proposing for you today. Thanks.
Thanks, Yvonne. Good morning, Mr. Chair and members of the board. It is a pleasure to be before you today. We don't get that opportunity very frequently. And before I jump in, I want to say kudos to Courtney Tyler. She has been phenomenal working with me and our staff and getting this item before you. So I'm going to discuss some of the revisions that we made in response to comments to further improve upon the draft that we had brought to you in April. Next slide. Oh, sorry. This is the right slide. Thank you. You've already moved it forward. Okay, so on the slide, this is not a complete list of the revisions, but these perhaps are the most meaningful ones that I'm going to discuss today. I'll go over these in detail, but to quickly summarize, first, we added language to consider racial equity in the enforcement process. We restored language to clarify the scope of Class A violations related to sewage spills. We further refined our proposed amendments regarding what constitutes a history of violations. We deleted the option for corrective action projects and added clarifying language regarding compliance projects and enhanced compliance actions. We also added language to encourage outreach to disadvantaged and EJ communities impacted by our settlements. And finally, we greatly expanded and refined our Appendix D, which categorizes each of the revisions as clarifications, procedural, or substantive. Next slide. In response to a discussion that we had with the board's Office of Public Participation, we added language in two places in the policy to make it clear that the water board should be prioritizing enforcement when there's an impact or threatened impact to Black, Indigenous, or other communities of color. This language is in addition to the existing proposed revisions which prioritize enforcement when there is an impact or threatened impact to disadvantaged or environmental justice communities. Next slide. With respect to the list of Class A violations that are provided in the policy, and those are the violations that pose the greatest threat to water quality, we had originally proposed language intended to clarify that only spills that impact waters should be prioritized. Commenters adeptly pointed out that our language would make nearly every discharge violation a Class A violation. And so we restored the reference to sewage spills within 1,000 feet of a municipal water supply and added a new sentence to make our original point that discharges of sewage solely to land that are promptly cleaned up are not Class A violations. Next slide. With respect to the consideration of a history of violations for purposes of the policy's penalty calculation methodology.
Sorry, I'm so sorry. Can you just go back to that last
Absolutely.
one? I hope that's okay. Just to, if there were a discharge of sewer that was, in a home or in sort of causing public health exposure, how does that fit? I know this is just, specific to municipal drinking water supplies, but just wondering if like a public health impact is already considered heightened.
Yeah, we'll take a look at the policy. I think there are provisions where we can consider public health in order to have, we need to demonstrate a threat to water quality or other water quality nexus. And so it may not rank as a Class A violation under the water quality enforcement policy. There's going to be nuisance considerations and health concerns, and it may be that it may be for another agency to take primary jurisdiction. It all depends on, of course, the facts at hand. And David is looking whether or not we have a health and safety specific factor under the enforcement policy. It is definitely, creating a health and safety nuisance would play into our triaging of it and our response to it.
Yeah, the policy does say that evidence of or threat of pollution or nuisance caused by the violations is another consideration for making it a priority. So certainly if there was a sewage spill that impacted homes, we wouldn't say, oh, that's a Class B because it doesn't impact water. Certainly we would bring enforcement on that. So
thanks.
Okay.
Sorry to interrupt.
No, thank you. Okay. So as I was saying, with respect to the consideration of what is a history of violations for purposes of the policy's penalty calculation methodology, our original proposal was intended to clarify that only self-reported, stipulated, and adjudicated violations of the water code or other environmental protection statutes should be considered when factoring a history of violations, and that merely alleged violations should not be considered. We also proposed to clarify that at least one violation can give rise to a history, and that under no circumstances shall history be assigned a factor of below 1. Commenters had several concerns with our proposed language. First, they objected to the reference to violations of similar environmental protection statutes as being too broad. We agreed and have narrowed this to violations of statutes for which the water boards have enforcement authority. Commenters also noted that just one self-reported violation in 5 years should not necessarily constitute a history of violations. We agreed and in response deleted the reference to at least one prior violation, but we made clear in our response to comments that the water boards have discretion to consider what is or is not a history of violations within a general framework, and that in some instances, a single prior violation may serve as a history of violations, whereas in other instances, it may not. Removing the reference really just serves to preserve the board's broad discretion here. And finally, commenters objected to including self-reported violations, since this could discourage accurate reporting, and more importantly, not all self-reported violations give rise to liability. After consulting with the regional boards and meeting with the commenters, we agreed to delete the reference to self-reported violations and the parenthetical that follows. And this is shown on the screen as a red text deletion, so that only stipulated or adjudicated violations shall be considered. Now, that doesn't mean that self-reported violations don't count. It just means that they should be alleged as violations in the complaint itself, rather than be used only to enhance liability for other violations. Next slide. We had originally proposed a new settlement option called corrective action projects, and these would have allowed a discharger subject to an ACL for violating a cleanup order to suspend a portion of the liability conditioned on performing required cleanup, as long as they could show they were unable to pay the liability as well as pay for cleanup. In response to comments and after internal discussion, we believe these projects function too much like compliance projects, which the policy expressly prohibits unless associated with MMPs against a small community with a financial hardship. Therefore, given this internal conflict with the policy's compliance project language, we have deleted the option for corrective action projects. We also added clarifying language regarding compliance projects and enhanced compliance actions to be consistent with the statute, which provides that compliance projects can be imposed either as part of a settlement or following a contested hearing, and that enhanced compliance actions are only allowed in a settlement context. Okay, next slide. In response to concerns that we should be doing more to engage with disadvantaged and environmental justice communities that may be impacted by our enforcement actions, we have added language to encourage the water boards to engage in outreach to those communities that may be impacted by SEPs and other settlement projects in their communities. Generally, we think these impacts will be beneficial since SEPs are by definition intended to improve water quality. Next slide. And finally, we made revisions to flesh out Appendix D, which details whether the policy revisions are clarifications, procedural, or substantive. And this is important because clarifying changes can be immediately applied upon adoption by the board. Procedural changes can be applied once the policy is approved by the Office of Administrative Law, and substantive changes can be applied to new matters prospectively after the policy takes effect. The bullets on the slide are not necessarily a full recitation of the proposed revisions. They are merely examples. One thing that I will mention here, and this is reflected in change sheet number 2 and shown in red text, is that the definition of what constitutes a violation for purposes of a history of violations is no longer a substantive revision if we delete the reference to self-reported violations. Rather, this should be identified in Appendix D as a clarification. Next slide. So what are the next steps? Should the board choose to adopt the revised policy today, the next steps are to send the administrative record to the Office of Administrative Law for review and approval. OAL will have 30 days to consider the policy. Once approved by OAL, the revised policy will then take effect. Next slide. We're here to answer any questions you may have, and thank you for your attention.
Thank you just for the good work here. I believe it's been definitely a needed project here to clarify, revisit, and ensure that our water quality enforcement is here coming up to muster. I think the reality is that in a warming climate, we well know with the continuing challenges and pressures facing on our water supplies, protecting them, ensuring that the enforcement components of those protections are here well articulated, but continue to be refreshed is really important. And so just thank you for the care that you've gone on in this project, the listening that's gone on, and the changes that have been made to reflect the board's priorities here. I know that it's a busy time, and so just at the top here, thanks for the good work here amongst it. Look to my fellow board colleagues if they have any questions off the bat. We have a few commenters, so looking forward to hearing folks' reflections on that. And we also had a comment earlier this morning already at public forum. Hearing no immediate questions, then let's move to our commenters.
Our first commenter will be Benjamin Harris, be followed by Nicole Granquist, Jared Voskel, and then Eric Oriana.
Good morning, board members. Can you hear me?
We can. Good morning.
Hi, good morning, Chair Esquivel and members of the State Water Resources Control Board. Thank you for your time this morning. My name is Benjamin Harris, and I'm the staff attorney for Los Angeles Waterkeeper. I appreciate the efforts that staff have put in to update certain aspects of the water quality enforcement policy. In response to comments that we submitted along with the California Coastkeeper Alliance, staff made many positive changes to the draft policy, including some of the changes that were just discussed in the presentation. I do want to thank staff for their close consideration of our comments and for the responses and corresponding changes made. I just wanted to point out that there are several key issues that we raised in our previous comments that have not been addressed in the responses to comments, and I wish to repeat 5 of them here for the board's consideration if I have the time to do so. First, the penalty calculation methodology still allows for wildly inconsistent penalties due to the exception in step 2 that allows for a lower starting per gallon amount for high volume spills. In our comments, we called for penalty calculations for all size spills to consistently start with the $10 per gallon statutory maximum, which is important to create consistency and public transparency about the methodology used to calculate and later adjust large penalty amounts. Having the discretion to start as low as $1 per gallon for spills above 2 million gallons creates a huge opportunity for inconsistent penalties down to 1/10 the statutory maximum for similar spills across different regions, where one regional board may elect to use the new minimum number and another regional board may elect to use a high number. The reason this is so damaging is that both approaches would lead to wildly different total base liability amounts under step 5. That step, as I understand it, is intended to provide transparency about the extent of base legal liability a discharger could be facing for its violations before other adjustments are made in the ensuing steps. The total base liability amount should be an objective and comparable number based on the statutory guidance, not one significantly affected by a water board's discretion, both because of an arbitrary gallon number associated with the discharge and because of an unexplained decision to dramatically reduce the starting per gallon amount used. Step 7 of the enforcement policy already includes a consideration of other factors as justice may require. That step provides water boards with the necessary discretion to ensure penalties are fair given the circumstances, including the ability to make a downward adjustment of the statutory maximum. But for clarity and predictability, that should be the only step where such discretion is exercised. And the last point I want to make on this is that the enforcement policy currently requires no explanation or justification for water boards using a reduced per gallon starting point under step 2, which deprives the public transparency regarding the reasons for those downward adjustments. And in the LA region, we've seen that play out before, where 2 different large spills used 2 different starting numbers, and there was no explanation for the reasons underlying the starting per gallon amount in those different complaints. Water boards, again, are free to make those decisions to reduce penalties under step 7, but they should only be required to do so under step 7 with full public transparency about the reasons that they are doing that. So to repeat, LA Waterkeeper urges the state board to do away with the exception for large spills under step 2 and instead require a full explanation of why any downward adjustments are made under step 7. The second point is that we commented to urge the state board to provide more guidance on when enhanced compliance actions are permitted above 50% of a settlement amount. We understand that some of that guidance is already in the SEP policy, but we think that guidance is too vague and insufficient to clarify what ECAs above 50% are generally authorized or may specifically be considered for an exemption upon approval by the Office of Enforcement. We request additional clarity on this point so that everybody can understand how those settlements might look for large spills. And I understand that might require revisions to the SEP policy. So if that is something that would be necessary, I would like to know when that update might happen. And also if I could just get a staff explanation about what ECAs are allowed above 50% right now, that would be much appreciated. Third, we urge the state board to continue to set enforcement priorities every 2 years at minimum, as previously required in section 2C of the enforcement policy. The responses to comments show staff believes it's unnecessary to continue to update priorities on a regular basis, and that it would be sufficient to update enforcement priorities only as necessary to allow more flexibility, for example, to respond to unexpected developments like the US Supreme Court's issuance of the Sackett decision. But why not both? Only requiring updates to the priorities as needed creates the opportunity to have no updates for many years when they might be sorely needed. If the board has complete discretion to update only as necessary, some kind of backstop must be included to ensure consistency and predictability and to provide public transparency. That backstop could be less frequent than every 2 years if staff believes that's too frequent, but I would suggest at least some kind of backstop for regular updates. Fourth, we urge the board to adopt a sunset clause for the exception to the 18-month enforcement timeline for issuing MMPs for stormwater violations. Revisiting that issue in 5 years will not ensure SMARTS gets updated timely to allow for MMP reports in the meantime. A sunset clause will provide that needed leverage to get funding for SMARTS improvements during the 5-year term of this enforcement policy. And if there are no updates achieved by the end of this current policy, then the exception can always be added back in with another sunset clause. But it shouldn't remain as an indefinite exception that would create a long-term incentive not to enforce MMPs for stormwater violations timely. Finally, we urge the board to provide guidance to regional boards on prioritizing enforcing MMPs for chronic and serious water quality violations, and to provide regional boards informational briefings on the results of the annual MMPs report. It is crucial to ensure that all MMPs remain enforced consistently statewide and to ensure suitable funds from MMP enforcement are available for compliance projects. I request a response to this point because I don't believe staff's responses to comments really address this proposal, and providing this guidance to regional boards seems like it would be pretty feasible and wouldn't take too much time or energy. That's all I have for now. Thank you very much for your time and consideration.
Thank you for yours as well, Mr. Harris. Appreciate your good points here. I will have some follow-up as I listen further to folks. Next, I'd like to call up Nicole Granquist, to be followed by Jared Bosco, and I believe our last commenter here will be Eric Oriana. Good morning.
Good morning, State Water Board members. I appreciate your time today. My comments will be brief. First of all, I would like to thank Water Board staff for their thoughtful efforts on the enforcement policy and also their willingness to listen to comments that were provided to date. I thought it was a very thorough process, and we appreciate the response to comments and also recognition of appropriate changes. So thanks to State Water Board staff for that. The only comment that I wanted to make, and our client, the City of San Diego, provided comments on the enforcement policy. I'm here on their behalf, but quite frankly, my comment probably applies to any of the folks that I've represented over the years and will continue with State Water Board on enforcement actions. And that is, there's new language in the factors that are taken into consideration for setting a penalty. There are culpability, history of violation, and then cleanup and cooperation factors. And typically in the past, not always, but typically, culpability has sort of been the pre-event, sort of why did it happen? And cleanup and cooperation has been post-event, how did you respond? The language that is being proposed now has similar language in both the culpability and the cleanup and cooperation factor that talks about a failure to respond, a district failure to respond to previous informal or formal enforcement by state or regional water board staff with respect to notifying the discharger about a potential violation. And it allows sort of that fact, this, whether or not there was a response to staff's informal or escalating formal enforcement before an ACL, to be used in both the culpability factor and also the cleanup and cooperation factor. So obviously the concern from the regulated community is sort of this idea that there might be, for lack of a better word, a little bit of a double counting in these factors that are multipliers that are on top of one another. And through the process of working with State Water Board staff, I think we understand their perspective that if there is a discharger who has not responded to repeated efforts by staff to identify and remediate a compliance issue. We certainly understand the State Water Board staff's perspective that that could be taken into consideration in cooperation factors. But we also wanted to point out sort of the sort of other fact pattern where this could arise and be more problematic. So in a circumstance where there might be something going on where there's repeated efforts by water board staff to get some discharger into compliance, and they just simply fail to respond, they don't do what is said, we certainly can recognize the culpability and cooperation having some equal weight in those multipliers as to those facts. When there is a particular event, in the absence of a circumstance where there has been informal or escalating actions by State Water Board staff, and you just have an event, an unauthorized discharge, perhaps a unexpected spill, et cetera. I think the concern that the regulated community has is that the culpability and cleanup and cooperation factors will both sort of immediately be used to increase those multipliers with that same language. And I think from our perspective, if it is a standalone event and we don't have the history of sort of not responding to an NOV or some other informal enforcement, that cleanup and cooperation should maintain its sort of after the event consideration, that it really would be culpability for why this spill happened, and then cleanup and cooperation post-event of how the discharger responded, and that those should be sort of considered somewhat separate. I actually think the language in the current policy allows that and sort of supports that concept because the language currently states that in the cleanup and cooperation factor, it says a reasonable and prudent response to a discharge violation or a timely response to a water board notice of violation order or similar communication can be used to adjust the cleanup and cooperation factor. And really the primary sort of basis for our comment today is to sort of request and underscore that or be respected, and that there are going to be circumstances where cleanup and cooperation really should be distinct from culpability, and that it should be after event. And then we recognize there could be some circumstances where, by respecting the that there could be a circumstance where there is significant pre-enforcement before ACL, and that the water board staff wants to use the latter portion of that or language to increase the multiplier for cleanup and cooperation. So I think our efforts are today just simply to emphasize that and to request that water board staff understand that in cleanup and cooperation, the sort of what I'll call the look back of why it happened and did a discharger fail to undertake action might not always be appropriate to apply sort of the same facts and increase the culpability multiplier while also sort of simultaneously increasing the cleanup and cooperation multiplier. I know that's sort of a lot to say, and when you're in the enforcement spreadsheet, it makes sense when you're doing the sort of math of multipliers, but the primary issue is we just simply want to make sure that these multipliers are used as much as distinct as possible, except for those circumstances where it really does make sense to be increasing the multipliers for sort of the same reasons. You can understand from the regulated community as penalties have grown in terms of their magnitude, those factors really do matter. They really do increase the penalty, and we want to make sure that there isn't sort of this automatic, if it goes up for culpability, it goes up for cleanup and cooperation, and really respecting that or for the more one-time events where you don't have so much of this failure to respond to an NOV or a pre-enforcement action. So really, this is quite frankly more of a general sort of statement so that the water board understands some of these nuances in the event that any of this ever later sort of appears on your doorstep rather than a specific change request. And so we wanted to raise this generally to make sure that the water board was aware and that we could obtain whatever feedback Water Board staff or Mr. Boyers wants to provide in response to this comment. And we thank you so much for your time and the efforts today.
Thank you, Ms. Quenquist. I appreciate the flag and concern of essentially, a multiplying factor happening between culpability, cleanup, and cooperation, and any failure to respond in one component of those ending up kind of magnifying them and being able to better distinguish and having nuance amongst that and not just allowing it to multiply up. I hear the concern. I appreciate it. If there isn't anything that folks want to jump in now, we'll hear a couple more commenters and probably have more comment around that and other points. So thank you very much, Ms. Quenquist. Thank you. Thank you.
Thank you so much for your time.
Really appreciate it. Next, I'd like to call up Jared Voskuil, and will be followed by last commenter, Eric Oriana. You may need to turn the mic back on at the top. Yeah.
Hi, good morning. Congratulations, Courtney, on the recognition. It's very deserved, and you've done an excellent job. Well, good morning. I'm Jared Voskuil on behalf of CASA, the California Association of Sanitation Agencies. We represent nearly 140 agencies across the state that provide wastewater collection, treatment, resource recovery, and water recycling services. I want to pause maybe at the top here just to acknowledge a year ago, we were here on the reissued order on the statewide sanitary sewer system waste discharge requirements. And it's hard to believe that was just 12 months ago. It feels like there's so much that you all take on that we're here responsive on. And some months it's probably feels like I'm here every meeting you have. You gotta grab on tight and buckle up. And so we're moving into 2024. You still have DPR next week. But I just wanted to kind of pause and acknowledge that. And then also just seeing you all here in person. I've seen some of them on airplanes before, going to conferences, and it's good to have the dialogue in person. Two really main comments. One is one of gratitude, and the other is just kind of echoing what Nicole explained. From a process standpoint, this has been a really desired manner of a process. You provided notice in February. This was coming out. You gave us till the end of April to provide comments. And then when, some of the issues were being worked through, the August adoption date was pushed back just a few more months, but those 3 or 4 months really make a big difference in us working through these items. There was the response to comments, which was very diligent. And I know there were a lot of comments that were put in there. We had teams of attorneys working and reviewing this, trying to understand how does all this work, because it's so consequential. And I think in the realm of the reissued SSSWDR, we thought there could be some interesting interactions that we hadn't had to think about before. But through all that process, we were able to relay that, have those meetings with staff, council, and then go through that response to comments and have the last dialogues to get to these change sheets. And so in the whole, a few items we are still probably in a little disagreement about, but really overall, just want to commend the process there. And then also, like I said, so many moving parts, but all these things in Appendix D with procedural and substantive and clarifying, and that was an entire other layer of you make a change to the policy, how does it correspond there? But I mean, really, such meticulous work. And so as we were going through all that, it was good to see what had been responded to. And so I think really the largest concern for us was what Nicole identified in terms of, that pre and post event factor of how it interacts with the calculation of the penalty. So I'm sure there'll be some dialogue, but it seemed like there were some pretty easy ways to provide a little bit more clarity or distinguish when that type of fact pattern Nicole identified, and how those culpability factors, or if that's a cleanup and cooperation factor, but we'd appreciate that, some kind of distinction there to clarify it. And then beyond that, just thank you again, and hope you all have a good holiday season, and we'll see you in the new year.
Likewise, and thank you for that, Mr. Voskuil. Really appreciate the feedback and engaging here on this project. Last commenter, Eric Oriana. Good to see you, Mr. Oriana. Good afternoon now.
Good afternoon, Chairman. Hello, board members and staff. I just wanted to quickly say, I don't know if I'm correct, but I think it's Miss Morgan's, board member Morgan's birthday tomorrow. So happy early birthday, board member.
Here, here.
Well, then, just wanted to share some comments in response to the water quality enforcement policy. We wanted to just thank board staff for considering the comments that Community Water Center submitted earlier in this year. We also provided verbal comments. And so just thanks for the process and being able to participate. Wanted to share some comments here. And I guess one of the overall theme of the comments, and I guess one of the things that I have to balance when I come to the State Water Board is when I speak to the communities that we work with, I have to recognize the lived reality that they live in and see that the reality is that their water is contaminated today and that there's still a lot of work that needs to be done to stop water from being contaminated. And so I think that informs a lot of the comments that I shared today. So in our letter, we highlighted how communities of color continue to face disproportionate impact of polluted drinking water. The California Drinking Water Needs Assessment identified nitrate and 123 TCP as accounting for nearly half of MCL violations, and that Latinos account for more than 58% of Californians served by failing water systems. And so one of the things that we're really excited to see is that the board adding racial equity in the prioritization of enforcement. We really hope that goes a long way, and I really appreciate that being mentioned. But also in the staff's response to comments, staff emphasized that enforcement alone cannot solve problems with contaminated drinking water supplies, and that's correct, right? But as an institution, the board's failure, not just this board, I'm talking about for a very long time, the board has failed to enforce water quality protections, and it's the reason why communities live and drink contaminated water today. And so the board has recognized this institutional failure to protect communities of color in its racial equity action plan and has identified increased outreach and engagement. And so we highlighted the board needing to augment its outreach to environmental justice communities and development of this policy. We're happy to see that this additional outreach was reported today during the staff presentation. For this policy and future policies, I think it's really important to strongly note how that outreach and engagement has influenced the policy development process and making sure that it's not just a checking the box on a step. We need to make sure that environmental justice communities are being meaningfully considered in the process. And so in closing, I just wanted to say we'll see this policy become adopted, and we really just want to see this policy live up to the principles that it has outlined. Enforcing water quality is really hard work, and we want to see environmental justice communities protected, and that needs to be done by challenging, the power and influence of industries that contaminate our drinking water. And so we need to prioritize drinking waters for future generations, but also mend the harm that has been done to past generations and the failure of the board as an institution. And so we hope to see the water quality policy enforced thoroughly, and we hope to see the fruits of this work mean safe and clean drinking water for our communities in the future. Thank you.
Thank you, Mr. Orellana. Appreciate the continued critical engagement around these discussions and the work. And thanks for the feedback. Board members, I'll note, I know Mr. Harris kind of talked about a backstop insofar as kind of a revisiting or, a intended revisiting. I think that, the opportunity and want to leave flexibility for a board, which I think we all know, we have a lot always kind of on the plate, but the ability, I think, important to kind of reflect and say, is there a moment where changes are needed, are important. And, this is where, this is just thought at the dais, and I don't want to just completely give direction on it, but a yearly enforcement update would actually be quite useful for this board, I think, not just on the water quality front, but even just kind of across the board, because there's water rights enforcement, there's drinking water enforcement work that we know this board is very much focused on. And there too are policies out there that, we haven't touched potentially or whatnot. And I think that as opposed to just kind of beginning to create an automatic trigger necessarily in the policy now, a request and, maybe just starting an expectation of a yearly update so that the board can then reflect on what is being enforced, what are, what are our priorities? Do we need an opportunity to direct maybe development of updates or thoughts can become a little more institutionalized. So I would support that. I don't think if there's something we need to do to make sure that happens, we can, but maybe just enough agreement here at the board as we all kind of reflect on what we've heard, maybe enough. Beyond that, quickly looking at my notes, I think, again, we heard from Mr. Voskel and Ms. Granquist about just the concern around non-response and, magnitude of non-response as opposed to, again, and kind of a pattern, a fact pattern, and kind of giving more weight to that as opposed to a signal non-response in the course of, what are different components, both pre and post response that, I think that flexibility is there. We didn't hear again a change for any language, but I think, heard certainly for me. And if anyone wants to reflect on that, they can and then look to other board members if they have concerns. But Mr. Boyers, if you wanted to, at least on that last one.
Yeah, I would be happy to gladly say that we generally agree with Nicole and Jared on what they're saying with respect to the relationship between the culpability factor and the cleanup and cooperation factor. In many cases, we see violations that are a one-time violation. You have an SSO that occurs on a Saturday and it stops. And then when we're assessing liability, we look at the condition of events or circumstances of events before the SSO occurred. What did they know? Did they fail to do maintenance? And that is culpability. And then we look at what was their response to the SSO. Did they, implement a bypass? How quickly were they responsive to the violation? And that is cleanup and cooperation. Where there is overlap, and we see this unfortunately quite frequently as well, is when there are continuing violations that are ongoing for a period of months. And the example that I'll give is the example that we provided in our response to comments. Say you have a construction site and you have failed to implement BMPs, things like straw wattles and blankets and erosion control. Regional board inspectors go out and they identify these violations and they tell the discharger you have some issues that need addressing. And then a month later, they go back and the issues haven't been addressed. So they issue an NOV. And they say, here's all the violations that we've identified, and we would love for you to address them. And then they come back a month later. And so you get the pattern, right? And so the violation continues over a period of time. In that instance, really, there's a lot of periods of culpability, which is before the violation. You have that initial inspection where we look at culpability being, what is the standard in the permit? Did you meet that standard? But then after you have regional board inspectors come out and tell you very specifically that you've got problems and they continue, that is an enhancement to culpability, because not only are you aware what's in the permit, but you've been told multiple times by the regulator that you have a problem that needs to be addressed. We think that also factors into cooperation. Cooperation looks at your response to fixing the violation. Those things go hand in hand when you have a continuing violation. So I think that's the point that the commenters were making. We agree with them. There is overlap when you got continuing violations. There's not when you have a violation at a distinct period in time.
Really appreciate that. Board members with further question or comment? Board member Firestone.
Thank you. So I have some clarifying questions, but actually I just want to start with some big picture things to get those out of the way and just emphasize, because I think one of the things that was brought up today was the enhanced compliance actions. And, we started to address and then deleted some of the discussions around related to corrective actions. And I think that's a reflection of the need to address that in future processes. I increasingly also feel like there's issues we need to address more broadly in the STEP policy, especially since we're having trouble finding a pot of money for at the state level to make the capacity building more broadly work for our racial equity policy. So I would just like to say, I would really like to see the sub policy, including, be the next thing that's brought back and discussed for looking at both addressing racial equity and clarifying some of these things on the enhanced compliance actions or even corrective actions. So just wanted to get that out there. I think that's not within what we're doing today. So wanted to get that out of the way. I also just want to agree, it would be great to have annual update on on enforcement actions. I think that's a great idea, Chair Esquivel. And I do think it's worth, though, I would agree that we have a lot of priorities, and setting, every 2-year process that may not be right. Maybe isn't the best use of time. I also, though, think that things get lost, and there is always so much priority that sometimes it is helpful to have a backstop, maybe a longer one. So I just want us to maybe consider whether it would make sense to do, instead of every 3 years, just say as necessary and at least every 5 years. It does seem like priorities change every 5, are worth revisiting every 5 years. And that still gives, I think is a reasonable time that doesn't create too much unnecessary work if not needed. But also, if there isn't a trigger to do it, there's always other priorities that seem more urgent. And it is a really important public process to be able to have those discussions and be really deliberate about it. And I think we would end up doing it within that time period anyway. Those were my main 2 points. I do have just a couple clarifications, though, if that's okay. The first was, I'm just wondering if staff could speak to the point that the LA Waterkeeper had around the large spill calculations. And I know we responded to comments on this, and I understand certainly when you get to really large spills, the numbers get just really, really big. But it did resonate with me that what we want to start with is a common metric where we understand what that baseline is. That sort of starting point, and then the reductions or enhancements. And so I'm just wondering if staff could just clarify a little bit how that's addressed, to have kind of a common starting point that then is changed and has guardrails on it for those large spills.
Sure. Just first, I want to just speak on the statewide enforcement priorities and hear what you're saying. I do want to say that we as a board have been bringing forward various enforcement priorities within the strategic planning every year, and that we do publicize our priorities on the website, and they are current and available and updated as that strategic plan or the focus of the board has shifted. So just want to be clear that that is a public process, and the document is out there, and those discussions have continued to happen. We did build in some room in the policy, and it sounds like we can make some tweaks to that language just to allow different reporting or is otherwise reported out, because we have not been doing a strict annual enforcement report. It's been more as part of the performance reports, more broadly, and then having keeping up that website with the priorities up to date. On the issue of the high volume discharge, this is something that has been in the policy for a number of years now through several updates. And really the intent is, as you pointed out, Board Member Firestone, that the penalties can get very large for some high volume discharges where, we've had potable water spills, we've had SSOs. And in order for our methodology to be meaningful, so that we're not just, it has helped us to start with that initial adjustment, that per gallon adjustment when the regional board finds that it's appropriate, and then use the methodology to do those adjustments instead of just doing one great big discount kind of at the end in a different step. So I don't know if David, if there's any other you want to talk about. I know that there's certain requirements under which when high volume applies and doesn't apply that the board needs to analyze, and it's all put out there in our attachment and our methodology.
Yeah, thanks, Yvonne. This language has been in the policy for a number of years. We think it's working well. I will say that if we were bound by a maximum and mandatory $10 per gallon calculation for all spills, we've had cases where it's in the hundreds of millions, if not $1 billion, for certain, spills from dams. And so Yvonne's correct. This is discretionary. It's not mandatory. It allows a process by which the regional boards can come to what is a reasonable and appropriate penalty given the circumstances. It is not, as I said, it's not mandatory. They don't have to use the high volume reduction if they feel that it's not appropriate. I will also note that one of the revisions that we're making in the policy in this go round is a clarification that, or I should say it's not a clarification, it's actually identified as a substantive change, that discharge violations that occur shall not be collapsed under the allowance for collapsing days. So perhaps as an offset to what LA Waterkeeper is saying, they should take some solace in the fact that if you do have an ongoing discharge that is a high volume, while they may be subject to or get the benefit of the high volume reduction, they will not also get the benefit of a decrease or collapsed number of days.
Okay, and that helps me. I do have one other question, but okay. If there was a commenter during public comment that couldn't participate, and it seemed like some of her questions were really things around clarification. And I'm wondering, I'm not going to get all of those right, and hopefully you can follow back up with her to clarify things. But I did just want to, on the question of private enforcement and when does a 30-day period begin? Is that something that you can just clarify now? Or
yeah, I can speak to it a little bit, then I think Michael might have something to say. So generally speaking, there were a number of questions raised. First, I wanted to address the fact that she wanted to know how to get status updates or to understand, to ask when enforcement was going to happen or bring a complaint to our attention. Complaints can come to the regional board or the Office of Enforcement through our Cali PA complaint process, direct contacts with staff, phone calls. We get them a number of ways, and we are responsive. It is the regional board's discretion on the first instance. Our lead of our prosecution team would make the determination. Generally, that's the AEO at the regional boards, the assistant executive officer, as whether or not after an investigation to bring forward enforcement and what level of enforcement to bring forward. There was some questions along those lines as well, whether it's informal, formal. And then the issue of when is it petitionable, generally speaking, when we enforcement is an evolving case. We do an investigation, we determine the status of compliance at that time. at that point in time and we gather information, anytime in the future, we could get additional information that would cause us to bring enforcement. When the regional board or the state board exercise their enforcement discretion, it's not set in stone. We never give away our ability to come back and revisit or bring enforcement as our understanding of the facts change, or our investigation continues, or the harm becomes more apparent. So it's really hard to say when, we're not set in stone until there is a final, whether it's a regional board or a state board action, making some determination that there won't be a future, that can be challenged through a petition. And this is where Michael probably wants to step in. But, often when you have an open investigation or ongoing concern, you're not going to have that final agency order, because again, we don't ever issue orders saying we're never going to bring enforcement for this.
Yeah, and I'll just pick up a little bit from what Director West said. First of all, after the public comment by Melissa Hathaway McKeith, I did go back and take a peek at what is in the proposal that's before you today. And there really aren't many changes from the existing enforcement policy. And the paragraph is on Appendix A, page 8 of the red line version of the enforcement policy as part of the agenda. And really, it is a pretty straightforward statement of what the water code provides for petitioning actions and what the water board's regulations provide. And Ms. Hathaway McKeith did make some references to there being some ambiguities about when the 30-day clock starts to run. And the paragraph is pretty clear from an action perspective, and that's driven by the water code when that 30-day clock runs. And inaction, which I think was really the gravamen of her concerns during the public forum, are triggered by when there's a very affirmative request for action to the regional board, there's essentially a 60-day clock for filing a petition for inaction because the region has failed to act. And I don't think there's anything that in the enforcement policy we could or would want to change, because those are driven by existing regulations and statute. And I think Ms. West really did get on the kind of key issues is, for some folks, they're not sure if they feel like the region is not taking an enforcement action, when the petition is ripe. And at that point in time, they should file the petition. If they've not gotten the responses they want, they haven't seen either a complaint filed by the Office of Enforcement or the regional board enforcement team, because time is running once they've made that formal request for action to the region. But as Director West said, at any point in time, some of these cases, they take a lot of time for them to be worked up and for the pleading to be in a form that the enforcement team feels it's appropriate to bring before the region. And so notwithstanding the fact that a petition for inaction may have been filed, there may still be further developments that play out before the regional board. So again, I went back and I looked at that language. I'm happy to talk to Ms. Hathaway McKeith offline. I'm not sure it's something that we could want or would want to try to change within the context of the enforcement policy.
Thank you, Board Member McGuire.
Okay, thank you for that. And I'll just say, just teeing off sort of maybe the lack of clarity on how things work or are intended to work amongst the enforcement policy and other statutes and regulations. I think Ms. Hathaway McKeith also requested some sort of training for attorneys. I don't know if that makes sense or if that's something that, you have ways of providing any information to help them better understand where there is areas of confusion. I'm not asking that necessarily today, but it's something to consider going forward, as it seems like the intent here is to help ensure better compliance with our laws and regulations and policies, and to the extent there's attorneys helping these folks out, dischargers, it would make sense that they're well-informed and understanding of our policies and procedures.
Yeah, I appreciate that. I mean, we are always accessible to opposing counsel with questions and concerns, especially on existing and active cases. We would be a little bit hesitant to provide legal advice to other attorneys on generally, but as far as our policies are concerned, yes, we have publicly available information, and we can consider. Our attorneys often participate in seminars and other legal education programs, discussing our policies and our programs and our enforcement approaches. But again, when we are engaged with a member of the regulated public, or even in the abstract, we're always accessible for questions and discussions and dialogue. We do have to be careful not to provide legal advice directly to someone who isn't our attorneys or, isn't our client, but I can appreciate that we often have those conversations with opposing counsels to help them navigate what our process and procedures are and where to find information about them.
Thank you for that. Just also wanted to concur with Board Member Firestone on the reporting of priorities. I think you asked for maybe a 5-year on the far end update. That to me makes sense. I'd like to see something like that included. Chair Esquivel, in terms of your ask for the annual report, I think that's also a great suggestion, and maybe even consider resolution language that would help support and emphasize that request. I think to me that would just make it a little bit more clear as we go forward in subsequent years that that's written down somewhere as an expectation. And then on the final area, I just wanted to touch on, I guess, would be sort of policy priorities. Board Member Firestone, you mentioned the SEP revisions and looking at workforce development and how those dollars are used. I was also initially intrigued by the corrective action project addition to the enforcement policy, and I understand why it's been withdrawn at this point. But I would say it's kind of an intriguing thought, and I just wonder going down the road into the future whether it would make sense to revisit that idea, either in its current format or some re-envisioned approach. And I don't know the answer, and I don't know that we need to figure all that out today. I would just ask that as you're considering next steps in terms of where do we go from here, what does maybe a future update to the enforcement policy look like, where does that fit within the SET policy and other revisions, that we think about all these different tools and opportunities to leverage thoughtful enforcement, and whether that something like this, and recognizing there's all these other compliance projects and there's enhanced compliance actions and there's SEPs, and I know there's a lot of tools in the toolbox, but it's just an interesting idea to me, and one that I'd like to hear more about in the future. Thank you.
Board member. Anything from other board members? I'm supportive of resolution language if that's helpful to make sure we have sort of a yearly check-in. I appreciate, Board Member Firestone, I think you're looking for something more affirmative of sort of a 5-year kind of mandatory check-in. I, would like to get maybe the sense from other board members if that's support and direction we'd like to go, or if, the check-in at this point is mainly there. And if so, try to provide some direction clearly from here at the dais on that.
I'd prefer the second option because I think we can always provide direction in the event that we feel that it's needed. We have a lot of priorities, and I'm always mindful about adding too much where it may not be necessary. So that would be my preference.
Okay, thank you, Vice Chair. Board Member Morgan?
I concur with the Vice Chair.
Okay. Thank you, Board Member. And so if, I'm not sure if folks want how much time, and on the other points that Board Member McGuire brought up, I'm not sure if there's any response from folks, if there's anything further, but pending not, then perhaps it's just a request for some additional resolution language.
Yeah, and can I just clarify what the resolution what the intent here is? So it sounds like we're not going to, there's already a requirement in here that they report back annually, and there's just a lot of discretion about how they do that, right?
So right now, the language is that as necessary, the State Water Board Office of Enforcement will propose statewide enforcement priorities. The prior language in the policy was on a biannual basis to propose those priorities. And so I was looking for a direction. Are we changing that language, or are we adding something to the resolution about, there's two things going on. There's proposing priorities, and then there's the check-in report. There is nothing currently in the policy about how frequently we come to the board as an office and report out on enforcement. There is a statement that the enforcement initiatives should be documented in an annual enforcement report or otherwise reported out to the public and reevaluated every year. So that's kind of the check that I think you were calling it like a check and kind of proponent that is still in there on an annual basis. So two different kind of issues, priorities,
Right.
and then the annual enforcement report on
Yeah,
initiatives.
And I think it's probably fair to kind of collapse those two insofar as an engagement, I would say, just to make it more clear then, but I don't know what's helpful. Mr. Lawfer.
It would, to hear from all the board members, whether the real goal, which is what I thought I heard the first go around with the annual, was that there be a report that is essentially presented to the board at a public meeting,
Right.
an opportunity for the stakeholders to come and hear what the enforcement activities have been across the water board's programs, an important piece of that, I think, over the last year, and for you all to digest that and hear from the public about that. Is that the primary objective?
Yeah, that's what I was
Yes.
trying to clarify.
Yeah.
So it's, my understanding was that was the primary objective of the annual reports. And that is currently what this says in the policy, is that there has to be some kind of public reporting. And then what our resolution would be saying is we want staff to bring a item to a board meeting or, public forum at the board, and that it would be organization wide.
So I think, just so that we can keep the board meeting moving, I'll propose some language, and if Director West has any concern, obviously if the board members do, but we could have a new resolved clause 5 that would follow all the existing ones, that just directs the Office of Enforcement to provide an annual report to the State Water Board at a board meeting on enforcement activities completed across the Water Board's programs during the prior year. It doesn't tie it to a particular calendar day in the calendar year. We can figure out when it fits best. It will probably be best for them to align it back. But does that satisfy all the concerns?
I appreciate it. That works for me. But looking to other board members and seeing odds.
Yeah, I just wanted, that's great on the reporting. I think I just wanted to close the loop on the other issue of just priorities and policies. So can you just clarify, this is a policy update. Is there a requirement currently to formally update the policy at a certain time?
This is the water quality enforcement policy. So just in the water quality program, there is a requirement to revisit the policy every 5 years, to review and update as necessary every 5 years. And then, I don't know, yeah, so then that's great. I definitely don't need another 5 years then on the priorities. And I agree that the priorities you're already bringing to the annual priorities discussion. So appreciate that.
Really appreciate it. And we may be able to have a motion including what Mr. Lawfer read into the record.
I'll make a motion with the additional resolve that was read into the record and 2 change sheets.
I'll second.
Thank you both. Ms. Tyler, can you please call roll call vote?
Board Member Morgan.
Aye.
Board Member McGuire.
Aye.
Board Member Firestone.
Aye.
Vice Chair Diadamo.
Aye.
Chair Esquivel.
Aye.
Thank you.
Thank you as well. The item is adopted. And again, appreciate everyone's good work and good discussion as always here at the dais on this. Let's go ahead and give ourselves here. We said we wouldn't begin our next item until 1 o'clock. We'll go past a bit 1 o'clock to give ourselves about a 50-minute lunch. So let's go ahead and come in at 1:30 and appreciate everyone's time today. Look forward to further discussion after lunch.
All right, we're at nearly 1:35. I think we can go ahead and begin. We're coming back here now to item number 6, which is an update here on the water supply strategy. Just really appreciate the amount of implementation and coordination I know that's been going on over the last year on this, and hand it over here to our folks on the panel. Ms. Wagner, good to see you.
Good to see you all. Yeah, and good afternoon. So I am Claire Wagner. I oversee the Sustainable Water Plans and Policies section in the Division of Water Quality. And my team and I work collaboratively to develop and implement water quality control plans, policies, and programs to promote integrated water resource management and water resiliency in California while protecting water quality in the environment. And I am joined today by my co-presenters, Jessica Bean from the Division of Water Rights and Anthony Navasero. I'm sorry about that. Anthony Navasero from the executive branch of the Department of Water Resources. And we're here today to present progress to date on some of the implementation actions from California's water supply strategy. It's a recent strategy to help increase California's water resiliency and adapt to a hotter, drier future. So the administration released a one-year progress report in October 2023, and it includes a summary of progress to date. So we're going to provide some highlights today. I'll start with a little bit of background on the water supply strategy and the Water Board's progress on actions related to developing additional water supplies. So things like recycled water, desalination, stormwater capture and use. And then I'll hand it off to Mr. Navasero to provide an overview of the Department of Water Resources work, followed by Ms. Bean's update from the Division of Water Rights. Next slide, please. So that was the slide that I just went through. So one more slide, please. Thank you. So on average, the volume of water used by people in California for agricultural, urban, and environmental purposes ranges from about 60 million acre feet per year to about 90 million acre feet per year. And an acre foot equals about 326,000 gallons. And this is about enough water to meet annual indoor and outdoor water needs for about 1 to 2 households. And what we're seeing is, climate change driving these wide-scale changes in atmospheric conditions. And so we're seeing things like decreased snowpack, which, historically has been about 30% of our water supply storage. We're seeing less rainfall, more arid soil conditions, and greater evaporative water loss due to these hotter, drier conditions. So with these conditions, we're anticipating about a 10% loss in our water supply by 2040. And we already have approximately 1 million Californians that don't have access to safe, clean water for drinking or sanitation. So this forecast really underscores the need for us to continue to invest in and take actions towards California's water security. Now, we're building on previous water supply planning efforts in California, such as the water resiliency portfolio. The administration released the water supply strategy in August of 2022, and it established new 2030 and 2040 goals for water conservation, recycled water, desalination, stormwater capture and use, as well as other goals to expand water storage both above and below ground. And to achieve these goals, the water supply strategy directs state agencies to work collaboratively on actions centered around 4 main initiatives. The first being to develop additional water supplies through recycled water and desalination. The next is to reduce the use of water in cities and on farms through more efficient water use and conservation. Then the next is to capture and store more stormwater so that when it does rain, we're taking advantage of these wet conditions, and then we're more prepared for the drier conditions. And then finally, just to improve all water management actions with better data, forecasting, conveyance, and administration of water rights. Some of the items in the water supply strategy had deadlines, others didn't. And so on to the progress that we've made. On the next slide, please. Starting with recycled water, the water supply strategy acknowledges that increasing the amount of recycled water produced and used is an essential component of increasing water supplies in California. And it sets a goal of recycling at least 800,000 acre feet per year by 2030, and then 1.8 million acre feet per year by 2040. And one strategy to help us meet these goals is by expanding the regulatory framework to allow a new type of recycled water. And so over the past few years, the Water Board staff have been working on developing the proposed direct potable reuse regulations that, if adopted, would add a new type of recycled water, new option for recycled water for California. So these draft regulations were released for public comment in July 2023, and those regulations will come before this board for consideration of adoption at the next board meeting on December 19th. The other actions that we're working on are centered around identifying and resolving obstacles for recycled water projects and also tracking progress towards these goals. So we formally convened a recycled water strike team in January of 2023 to support the development of new recycled water supplies. And the team is comprised of state and regional water board staff that work closely with folks in the recycled water community to identify permitting and funding obstacles for projects. And then they can work with agencies to try to resolve those obstacles, or make recommendations for a number of things like project-specific actions, legislative or regulatory changes, or other programmatic solutions that could lead to increasing production and use of recycled water. Now, one of the recycled water strike team's first actions was developing a list of planned recycled water projects that have the potential to be operational by 2030 and 2040 to get a better sense of, will we meet the recycled water goals in the strategy? So this was a collaborative effort with state and regional water board staff, as well as lots of folks from the recycled water community. We also used the state's volumetric annual reporting system to issue a voluntary survey last year for folks to let us know about planned projects, as well as potential impediments for getting their projects operational. So after compiling this list from a variety of data sources, we did some follow-up quality assurance, quality control checks, both with the regional boards and the water and sanitation agencies, and just wanted to say, thanks to everybody who was helpful and responsive to those surveys. That was really important information for us. So the good news is that this initial list provides an early indication that we're on track to meet the 2030 goals, but that we have more work to do to meet the 2040 goals. Next slide, please. So we're really fortunate to have a really powerful tool to help us track progress towards these goals. We have the statewide data set from the Water Board's volumetric annual report of wastewater and recycled water that water utilities and sanitation agencies report annually. We now have 4 years of data, and the portal for the 2023 data is about to open January 1. Those data will be due April 30th, 2024. But what we have on this slide is just a snapshot of the data so far. And the blue bars at the center on the bottom of this slide, we're seeing the amount of wastewater coming into the treatment plants seems to be decreasing. This could be related to things like conservation efforts or drier conditions. The discharges of treated wastewater are in the gray bars. We're also seeing a decreasing trends there. And then the recycled water use in purple is increasing. And we saw approximately 749,000 acre feet per year of recycled water used in 2022. So you can see this in context of the water supply strategy goals in the figure on the left. The 2022 recycled water use data is about 51,000 acre feet below that 2030 goal. But as I mentioned, we think we're going to be able to meet that based on the plan list of projects that the strike team put together. But to ensure we can meet this 2040 goal, we can do things like use this geospatial data set to identify regional opportunities and areas to potentially increase recycled water. We're going to need to continue to identify and work through impediments such as permitting and funding obstacles, and then also continue to support research to address the technological challenges and any knowledge gaps for recycled water applications through our recycled water research program, as well as other partnerships. And then another key aspect to this work will be to continue to coordinate with the Division of Water Rights as they oversee the wastewater change petition process and ensure that as we're promoting recycled water, folks are considering impacts to downstream users as well as needs for fish and wildlife, particularly in inland areas. And so although we're anticipating there will be some opportunities to increase inland recycled water, we know that brine disposal is going to continue to be a challenge. And so we're anticipating that most of the volume of recycled water to meet that 2040 goal would come through recycling wastewater that's currently being discharged to the ocean, which is approximately 1.45 million acre feet per year right now. So this full data set is publicly available and can be accessed on the California Open Data Portal. We have a lot more stuff on our website, so go ahead and check it out. Pretty cool. Next slide, please. Shifting to desalination, the strategy has a few implementation actions for both brackish groundwater desalination and seawater desalination. And the water supply strategy identifies the need to better understand the untapped potential for brackish groundwater desal in California. So the Department of Water Resources is working to identify the existing brackish groundwater desal projects, as well as the projects that are planned to come online by 2030 and 2040. Again, trying to understand like how close are we to meeting the goals in the strategy. Now, to better understand the potential for brackish groundwater desal in California, the state's been coordinating with the regional water or state water board has been coordinating with the regional water boards as well as the U.S. Geological Survey to develop an initial report that we're in the process of finalizing. And it's going to cover, the available data that we have, the data gaps that we need to fill, as well as some site-specific characteristics that could be used to inform areas with this potential to develop brackish groundwater desal as a water supply, as well as get a better understanding of the volumetric potential of those groundwater basins. So the next phase after that would be to continue to work with our groundwater ambient monitoring program at the State Water Board to work to fill some of those data gaps. And then as well as talking to the water utilities to get a better understanding of impediments and other feasibility considerations that would impact the development of brackish groundwater desal projects. So moving to seawater desalination, the State Water Board convened the Seawater Desalination Interagency Group, which is comprised of 15 state and federal agencies that are involved in various aspects of planning, permitting. They can issue lease applications or conduct environmental review for proposed seawater desal facilities. This group met over the past year and developed a report that outlines criteria for siting desalination facilities where they're cost-effective and environmentally appropriate, with an eye towards streamlining and facilitating approval both under our existing regulatory requirements, as well as identifying potential changes to the requirements to better facilitate approval of seawater desal facilities in the future. So this draft report was released for public comment in July, and we received a lot of feedback from the public. The Desalination Interagency Group reviewed and considered all of those comments, and a lot of the commenters were really requesting changes that would need to be implemented through either legislative changes or changes to the California Ocean Plan, both of which have a much more extensive public process than what was done for the siting report. The siting report's also non-regulatory, so it has no force or effect. And so we're seeing the siting and streamlining report as really just the start of the conversation, and want to let people know that there's going to be many more opportunities to engage with us on these issues as we move forward developing the staff recommendations for proposed amendments to the desalination requirements and the ocean plan that would come to this board for their consideration. And part of this work includes our commitments to engaging with tribes and disadvantaged communities to identify any potential impacts to those communities, as well as environmental justice concerns. So much more to come there. Next slide, please. All right, moving on to encouraging stormwater capture and use. The water supply strategy includes volumetric goals for statewide stormwater capture and use. And the state water boards strategy to optimize resource management of stormwater program, or STORMS, is our program that's charged with implementing projects or plans or policies to increase stormwater capture and use both through regulatory or non-regulatory approaches. And in 2020, the STORMS team collaborated on a report with the Southern California Coastal Water Research Project to identify potential methods to quantify stormwater capture and use. So building on this work to meet one of the directives in the water supply strategy, the STORMS team is contracting with California State University, Sacramento's Office of Water Programs to develop a method to estimate the amount of stormwater captured statewide. So currently in California, there are a few municipalities that are tracking the actual amount of stormwater collected by their systems. Often this is for their large centralized systems, but we don't really have a statewide or a regional method or data set to estimate capture and use with some accuracy. So the method that the Office of Water Programs is developing will enable us to track progress towards the stormwater capture goals, as well as make projections about future stormwater capture based on new infrastructure, variables like precipitation or other impacts from climate change, like extended drought periods or more intense storm periods. So we anticipate that this work will start in April and then continue through June of 2026. But to further understand the potential amount of water available for stormwater capture with some accuracy, moving forward, we're thinking about taking a phased approach, starting with analyses at smarter geographic scales and then building towards statewide. So as I mentioned, some municipalities already have implemented tools to estimate current capture and also evaluate their maximum stormwater capture potential in their areas. But not all municipalities have the funding or the resources to develop or implement those tools. So the STORM staff is developing a GIS-based methodology that could be used by municipalities to develop their own estimates for current capture and also for how much urban stormwater or urban runoff is generated and could be captured in their city or county with additional stormwater capture projects. So we're planning to make this resource available for municipalities to use in their planning efforts and hopefully be able to identify local opportunities for, as well as barriers to capture and use in their areas. Potentially, they'd be able to establish goals at local or regional levels. And then a really important factor would be able to characterize the investments needed to increase stormwater capture and use in their areas. And last on this, we're thinking that this too might be able to identify opportunities for regional partnerships among groups like stormwater and watershed planning groups, water districts, and groundwater sustainability agencies, as we think these partnerships are really essential to taking an integrated water resource management approach, addressing some of those impediments, and then also make that connection between stormwater capture and stormwater use. So we've talked about the importance of having the right data, usable data to inform decision-making. Another project the STORMS team's been working on towards this effort, they're wrapping up the revised draft of a proposed policy that would require consistent reporting for municipalities to annually report the cost of their municipal stormwater permit implementation. So if adopted, this statewide data set could be used to characterize the true cost of stormwater management, as well as inform future investment needs for stormwater infrastructure. In addition to this work, one of the next priorities for the STORMS team is to develop a proposed statewide policy to encourage stormwater capture and use in a manner that's protective of groundwater. So we're anticipating this project to kick off officially at the beginning of next year. And then as the STORMS team starts to wrap up some of their current suite of board priorities, we're anticipating being able to shift over conversations to identify the next batch of STORMS priorities for the team, and then engage more on the last stormwater action in the water supply strategy, which is to explore potential paths for stormwater crediting systems. So I'll talk about how to stay up to date on all of this work at the end of the presentation, but now I'm going to hand it off to Mr. Navacero from the Department of Water Resources.
Thank you, Ms. Wagner. Good afternoon, Board Chair Esquivel. Thank you for the opportunity to present to you and represent the department and what it's been working on since 2022 on the water supply strategy. Let's see, next slide, please.
So I'm just going to go over the directive and what we've been doing, the actions taken. This first slide here regarding expand water supply or storage, excuse me, the directive to expand average annual groundwater recharge by at least 500,000 acre feet. Thanks to extraordinary wet winter, the department estimates California recharged 3.8 million acre feet of water from the winter and spring of 2022-23, not counting natural recharge. The volume of water is more than Lake Oroville can hold. Much of that recharge occurred under the State Water Board's temporary and streamlined permitting process as directed in the water supply strategy and through executive orders. Also, the temporary pumping program that we've developed at the department, many irrigation districts and landowners diverted flood flows onto working lands and lands being prepared as recharge basins. The department assisted local districts acquire additional temporary pumps to increase the diversions of flood flows that pose an imminent flood risk. Also, the department launched a rip and chip program to help irrigation districts get the necessary equipment to remove orchards and vines to increase the percolation of flood waters into the aquifers on their land. In addition, SB 122, in July 2023, the governor and legislature enacted the state bill, which clarifies legal and regulatory requirements to allow for diversion of flood water for underground storage while maintaining conditions protecting the public health and fish and wildlife. The next directive, work with local proponents to complete 7 Prop 1 supported storage projects and consider funding other viable storage projects, surface storage projects. Currently, the Water Commission has approved $277.5 million in funding for the Harvest Water Project, which is a conjunctive use project that proposes to deliver up to 50,000 acre feet per year of tertiary treated water from the Sacramento Regional Wastewater Treatment Plant to more than 16,000 acres of agricultural and habitat lands in the southern Sacramento County. It is the first project to receive their final WISP funding award. It's anticipated the next recipient may be the Los Vaqueros Reservoir Project in 2024. The development of a WISP strike team, the California Natural Resources Agency established an interagency strike team to facilitate permitting of the WISP programs. The high-level team, which includes top regional staff of the U.S. Bureau of Reclamation, meets at least monthly to identify barriers and develop solutions as WISP projects come online. In addition, SB 149, streamlining and accelerating the construction of critical infrastructure projects, helps to speed up judicial review for water storage projects without reducing the environmental and government transparency benefits under CEQA. Next, the directive regarding San Luis Reservoir, complete the seismic upgrade and expansion. The project's been approved between the Department of Interior and San Luis Delta Mendota Water Authority as part of a seismic retrofit. The San Luis Reservoir expansion project will create an additional 13,000 acre feet of storage in the San Luis Reservoir. As of October 2023, the federal government has committed $95 million to the project. The feasibility report and environmental review documents are complete, and a design process began last month, with a construction schedule to begin early 2026. Administer funds for local dam safety projects and flood management. 2023-24 state budget included $50 million for grants to help dam owners make repairs that will improve public safety. The department expects to solicit applications in mid-2024. For SB 146 progressive design build projects, SB 146 gives the department the authority to use progressive design build methods on projects related to dam safety and certain other types of projects. This method offers a more flexible alternative to the traditional project delivery method and allows the department to administer the grant program with guidelines rather than regulations. And I think we're on to the next slide, please. This is regarding conservation.
The directive advanced adoption of proposed regulation to make conservation a California way of life. I believe your staff has already updated you recently, so I'll skip that directive. I'll go to the next one regarding support flexibility in local land use decisions to protect beneficial use and users. The department has developed the Land Flex program to coordinate in coordination with the California Department of Food and Ag, and has awarded to date approximately $23 million to several San Joaquin Valley groundwater sustainability agencies, so they can in turn award funding to local growers to protect drinking water supplies in underrepresented communities and transition this to sustainable groundwater use. Landflex aims to temporarily halt pumping for 1 year on ag lands adjacent to vulnerable drinking water wells, and long-term will permanently eliminate groundwater overdraft pumping on each enrolled acre. In addition, the multi-benefit land repurposing project administered by the Department of Conservation awarded $40 million to regional collaborations led by the local groundwater sustainability agencies to plan and take action towards strategic following plans and repurpose those lands to achieve ecological, social, and economic benefits. In June 2023, the Department of Conservation awarded $35 million to regions that are adapting land use to improve sustainability of groundwater basins. In addition, 2022-23 state budget authorized $110 million for a grant program at CDFA to improve agricultural irrigation efficiency and $15 million to CDFA's water efficiency technical assistance program. Next slide, please. Water resources. The directive continuing to invest in the human and technical resources needed to improve predictions and forecasting for water supply planning. The department has made significant improvements in its water supply forecasts, including updating historical climate data averages to the most recent 30-year period to better reflect current conditions. Also, during the winter and spring of 2020-2023, the department completed 65 airborne snow observation data collection flights and produced over 120 snow hydrology modeling reports for 18 watersheds in the Sierra Nevada and Southern Cascade Mountains. This was to improve water supply forecasting. During the flood events in late 2022 and first half of 23, work funded by DWR and led by the Center for Western Weather and Water Extremes, including forecasting, warning, and decision support tools, was critical to flood response. DWR and the National Weather Service used the tools to not only assess the potential for major flooding from incoming storms and prepare emergency response activities, but also coordinated with reservoir operators and flood control managers to maximize water storage management. The department also developed a website where anyone can use snow data. It can be accessed through the California Water Watch website or snow.ca.gov. Additionally, improved prediction for forecasting for water supply planning. The department continues to support forecast-informed reservoir operations, or FIRO, which assess and coordinates with partners such as the U.S. Bureau of Reclamation, the U.S. Army Corps of Engineers, and other reservoir operators to analyze the potential use of FIRO to modify reservoir control manuals to improve water supply management. FIRO uses improved weather and water forecasts to help reservoir operators decide when to release or hold water. SB 19, Stream Gauging Prioritization Plan. The 2022-23 budget included an increase of $23.9 million in 2023-24 and $2.8 million in 2024-25 to support reactivation and development of priority stream gauges, consistent with the implementation of the SB 19 Stream Gauging Prioritization Plan, which aims to close gaps in the network that tracks stream flow. Next directive, advance the design of and draft environmental impact report for the proposed Delta Conveyance project. Not that that's the focus of today's briefing, other than the department has scheduled the release of the final EIR on the proposed Delta Conveyance project later this month. The next directive, support costs for repairing 4 major San Joaquin Valley canals damaged by subsidence. Funding improvements for Kern Canal. Owned by the U.S. Bureau of Reclamation, it has lost more than 60% of its original conveyance capacity in the middle section due to land subsidence. It plays a key role in the irrigation of 1 million acres of farmland in the Central Valley. So in March of 2023, the department released $29.8 million in funding to the Frank Water Authority to repair segments of the Kern Canal. Next, studying the feasibility and design of repairs to the California Aqueduct, Delta Mendota Canal, and the San Luis Canal. The department and partners are studying the feasibility and design of repairs to the aqueduct and the various canals. Those components of water infrastructure are key water delivery systems to the San Joaquin Valley that have lost carrying capacity due to subsidence damage. The 2021-22 and 2022-23 state budgets included a total of $200 million towards cost to repair those 3 canal systems and the Kern Canal. Additionally, legislation enacted in 2023, Senate Bill 146, gives the department expanded authority for canal repair and certain other types of projects to use a design build method for a more flexible alternative to the traditional project delivery method. And that concludes that slide, and I'll hand it over to Ms. Bean.
Thank you. Good afternoon, board members. I have a very brief update for you on modernizing our water rights. And we have 2 directives here: to digitize our existing paper records and rebuild the state's water rights data management system, and then to develop a pilot project to bolster our efforts to measure water use and availability in real time. So we just started our pilot project for the digitization yesterday. We've got a great setup going on, giant printers, because all of these old records are not standard sized. They are difficult to scan. And so we're running some processes and evaluating how do we do this most effectively? How do we streamline things, come up with some best practices? And then ideally, in about a month, we'll be going full scale, kind of running through really processing those completely. In terms of the rebuilding the system, you've heard some updates on it. The system itself is called Cal Waters. That's Cal-WTRS, because we love our acronyms. But Cal Waters is going to be the new reporting system, and we are underway moving forward on that. We've had some public outreach, also formed an advisory group. And then in terms of the telemetry pilot project, which is the second directive there, we are working with the California Water Data Consortium on the project. We are in contract with them. They are interviewing folks from across the state on different practices, experts, just really getting the information from leaders to find out about monitoring networks, equipment, data management, and they are expected to have a draft report to us early next year on that. And that's it for me. I will pass it back to Claire.
Great. Thank you so much for those updates. Just want to acknowledge, we're sitting here, but there's many other people throughout the state and regional water boards who are working really hard, also at the Department of Water Resources. So wanted to acknowledge the broader team, as well as all of our partners who are working with us on this towards equitably increasing water resiliency in California while protecting ecosystems. There's a lot more work ahead. So that continued collaboration and coordination with all the practitioners out there is going to be essential. Special thanks again to the sanitation agencies, water utilities, and municipalities who partnered for our team's information requests and continued partnerships. So you heard a lot of progress, but with each of these accomplishments, there's going to be a lot more to do. So
We will come back periodically, but one of the best ways to stay up to date with everything that's going on is to read the State Water Board's Executive Director's Report. We have a section dedicated to the water supply strategy activities. For the public, we've got a number of Gov delivery topics where you can subscribe to a specific topic if you're interested, as well as the Department of Water Resources has a lot of great resources, not only on their web, but ways to stay connected with them as well. So that concludes our presentation, and we're happy to take any questions.
Thank you all, and to your acknowledgement, I know that there are incredible teams that are all working on implementation of the water supply strategy and all the engagement that it takes. And so just join you in really acknowledging the work that's gone on in this last year, and particularly those that have come in the door, really engaged with us and made sure the products that we're getting out at this point have been the best we can possibly synthesize. There's a lot of exciting work that's going on, and especially connecting this all, being able to articulate it through the water supply strategy, and really lessening that dependence on exported supplies, if you will, and really focusing on local management of critical resources through recycling, desal, and recharge is great to see. And especially the way even water rights modernization is weaved into the document to really figure out how we look at the system. So thank you, Mr. Navasero, and importantly, DWR and all the leadership that it's taken to get us all here collectively. We have one commenter, but I look to fellow board colleagues if they have questions off the bat on anything that we heard today or anything as we implement the water supply strategy. Board Member Firestone, please.
Sorry,
Thank you.
I think I'll just
sorry.
ask.
Thank you.
I'll just ask. So much good information, so exciting. Echo all the thanks and recognition for the huge amount of work and folks working on this. For the recycled water goal, although we've finished our work, is the final number not out yet, or did you say it and I missed it? For the 2040 goal.
Are you asking, is the 2040 goal there, or do we think we know how much recycled water we would get from the facility list that we put together?
Yeah, do we think that we've identified facilities that would be ready to go by 2040 that meet that 1.8 million acre feet? It sounded like we thought we would exceed the goal based on the project list for 2030, and I just didn't hear if we yet knew whether we thought we would meet or exceed the goal for 2040.
So for 2040, based on the list of projects that we currently have, we don't think we're going to meet it. So the number, it should be, we're finalizing the report. So I did not say the number, but we're going to be pretty short. But that being said, we have
There's still time.
There's still time, and it was an initial investment in that. So good news for 2030, but we definitely want to work more to see what's it going to take to hit the 2040. So that's kind of our next steps.
Because I heard you say there's plenty of effluent discharge to the ocean. So there's plenty of potential volume of water to be recycled to meet that goal. But you haven't finalized and publicly released the exact project list, but there's more work to do to get projects ready to meet or get projects proposed to meet the 2040 goal at this point.
Yes, for sure. To address the impediments that, are for sure there.
Great. Okay. That's helpful. I've been wondering that, and it's exciting that we've done all that work, and I look forward to that report. Really, my comment is that I can't help but make is just that all of this work is necessary to meet, our water supply needs for this hotter, drier, and more extreme future. And it's going to cost a lot of money. And we have a lot of costs already from underinvestment in the past to date. And so I know one piece of the governor's water supply strategy is around looking at affordability, but I think increasingly we're really going to have to look at both, certainly this administration has identified, and we are part of investing a huge amount of public money into this kind of infrastructure, but there's still a huge need out there. And I know in addition to public investments, just looking at how water agencies, what their local funding sources are, what the flexibility to provide more equitable rates are. And, and then of course, we're doing work on trying to, on our arrearages program for water shutoffs and those sort of emergency situations. But just want to, continue to emphasize the need to be putting effort into figuring out how we navigate the affordability challenges ahead, even as we're implementing and moving forward and doing all this critical planning work and investments.
Here. Thank you, board member. Completely plus up those comments and concerns. And to your point, glad that we do have mention in a paragraph within the water supply strategy around affordability, because it's a common nexus amongst us all. I even think of, I know our discussion that we're having around the conservation budgets and points folks are making around affordability there too. I think we're there to acknowledge that and try to best figure it out. So thank you for that. Board Member McGuire.
This is great. I've been looking forward to this presentation and the update for a while, and just really am encouraged by all the progress that's being made on the water supply strategy. It is so timely and so necessary, and there is certainly a lot of work to do. I think that's an understatement. Good questions, and so I'll pick another topic, and that is stormwater capture and use. And I'm really excited about the tools that are being developed by Sac State to help better quantify that. I think, like with recycled water, where when the recycled water policy was initially adopted, there was an aspirational number put to that in terms of how much recycled water we want to achieve in the state. And as time's gone on, we've had this opportunity to really refine that, and now really getting more precise with what's truly possible. And I'm looking forward to that same kind of rigor being applied to stormwater. I think with our storms program, with these tools being developed, thinking about the MS4 programs and watershed management plans and different approaches that are being used around the state, there's a lot of opportunity there. But it's unclear to me still what that opportunity is in terms of a number. I think that the supply strategy goals are good, but I'll look forward to hearing more specifics as we go forward here. So just wondering, and if you said this and I missed it, I apologize, but could you just give me a sense of timing for when these deliverables might be arriving and folks could start using them?
So for the Office of Water Programs, the contract's starting this April, but it'll run for 2 years. So 2026 for the statewide accurate number of capture that we can use on an ongoing basis. So it's not like a one-time thing. It'll be a model that the staff can use to update the number periodically. For the second piece I mentioned was like a tool to give to people who want to use it. And that I'm thinking we can probably wrap up in the next year or so, and then build and refine that over time. So it's pretty easy to get a number that's like a little better than back of an envelope, but we're trying to do better than that. And so that's kind of the stuff that we want to refine over time, but obviously not taking too long to do that. So that second piece that it would be available to people, we're hoping to get out next year.
Great. I'll look forward to that then, maybe your next update or whenever that, right around that time, to start to see some better than back of the envelope numbers.
Yeah.
Thanks so much.
Thank you for that, board member. It's great to see really the data driving then this decision-making space, and being in this place where really being able to see the benefit of it and being able to actually drive toward goals here with information. I'll just note, I know a number of board members were recently at the Association of California Water Agencies, heard a bit of talk there from folks around why aren't we doing more on brackish? Isn't brackish cheaper, a first step before you're really even looking at ocean desal to try to maximize? And so glad for the products that I know that'll be coming out of that, so as to better inform when those opportunities are. So thank you. Okay, we have a couple of commenters. Let's go ahead and go to Kyle Rivers and then Jared Bosco.
Good afternoon.
Good afternoon. Good to see you.
Nice to see you. Thank you, board, for the opportunity to provide comments today. My name is Kaya Rivers. I'm a policy advocate at Community Water Center, highlighting the need to protect small disadvantaged communities' access to drinking water. Thank you for the update on the water supply strategy implementation, especially because of the unpredictability of climate change. We need to prepare for potential extreme wet conditions or flooding in 2024. And recharge can be used to prevent flooding and to restore groundwater basins. However, it is crucial that the State Water Board continues to uphold the human right to water and prevent further exacerbation of already widespread groundwater contamination impacting disadvantaged communities. If recharge is done irresponsibly, residents may be at risk of unknowingly consuming contaminated drinking water, as some contaminants like nitrate are undetectable to the human senses. Recharge in every case must be done with drinking water needs at the forefront, and in order to prepare for the recharge that may occur under the standard recharge permit process or through the emergency water diversion process under SB 122, we ask the state to identify locations best suited for recharge. Further, DWR and the board are required to map areas where recharge is unlikely to degrade water quality pursuant to this year's SB 659. The state should identify potential recharge locations that can be used to improve groundwater quality and quantity before that recharge happens. And in order to identify these ideal recharge locations, the state should use information gathered from groundwater quality monitoring data. Additionally, the state should map out locations that should be avoided for recharge in order to prevent negative impacts to groundwater quality, especially around disadvantaged communities. Additionally, the state must identify where water quality problems already exist and determine how recharge projects may negatively or positively impact groundwater quality. It is critical that this information gathered from this analysis guides future recharge decisions. The board can work with groundwater sustainability agencies who already have the responsibility to track changes in water quality. And the board can ensure that this type of groundwater quality tracking and monitoring is done diligently by using your authority and basins with field plans. These steps are crucial in order to prevent further degradation of water quality and protect communities' access to safe drinking water. Thank you for your time and again for the update and for the opportunity to provide comments today.
Thank you as well, Ms. Rivers, and appreciate the important points around groundwater quality protection, even as we, I know, pursue groundwater recharge, and appreciate, again, the engagement even with the legislature and making sure that we, at this point, have legal requirements to create certain products, which I agree are important to make sure we're being protective. Board Member Firestone.
Thanks. I was just going to use that opportunity to see if either the board or DWR wanted to provide any information or update on efforts to help map those areas, and either through the Sigma or other recharge efforts. I don't know if anyone wanted to speak to that.
Yeah, I could speak a little bit towards that. Excuse me, clear my throat. Last year we had great opportunities to do a lot of recharge projects, and we're looking for those same opportunities this year. As well as we've done some mapping, we've done the aerial electronic magnetic mapping. I believe 95% of it has already been completed. That data is available on our website for anyone to use and to look at as we start to develop profiles for the groundwater aquifers and understand where we can do better or increase groundwater recharge in different locations, especially to address disadvantaged communities that are impacted by dry wells. So yeah, we look forward to continuing to provide that information and to support those communities.
Thank you both. And what I know as well are, have been existing efforts like sustainable conservation and others. There's a groundwater assessment
tool, the GRAT, I think that folks have been working on. So I think there's looking forward to what I know will be a lot more to be able to add to what I know are really good data sets that DWR has done on electromagnetic, resistance and the best places to actually get water down into the ground. So yeah, thank you both. Really appreciate that. No further comment on that comment. Appreciate it. And we can go to Jared Voskuhl.
Hi, good afternoon.
Good to see you now virtually.
Likewise, long time no see. Sorry, I had to get back to my office for some other in-person meetings. Jared Voskuhl on behalf of CASA, the California Association of Sanitation Agencies. CASA represents nearly 140 wastewater agencies that provide the collection of wastewater treatment, resource recovery, and recycling services across the state of California. Very excited for this update as well, to concur with Board Member McGuire. I saw it was on the agenda earlier this fall and then postponed to now. We did read the executive director's report that did provide some of the update on the volumetric annual information, and we appreciated having that in writing. Just from the top, we want to thank the staff and the strike team that was formed to pursue the recycled water avenue. And even stepping back a little before then, we really just want to commend the governor's leadership on this issue. I think there were news and academic articles published in the wintertime of 2022 talking about the disappearing snowpack and what the situation could look like in 25 years. And within 6 months' time, this document emerged and several action items that were to be pursued to help get ahead of that issue in terms of climate change and those potential impacts. And so when we saw it called for a strike team on this recycled waterfront, we were very excited with that prospect, because this is so fundamental to what we do at CASA and for our member agencies and for water reuse. So, through that process, I think the very first meeting we attended with the strike team, it was Division of Water Quality, Division of Drinking Water, all 9 regional boards, and then I think myself, Sean Bothwell from California Coastkeeper, and Jennifer West from Water Reuse, and really seeing kind of behind the curtain of what it looks like for the State Water Resources Control Board and all 9 regional water boards to collaborate and dialogue and make the priorities for this strike team. It really took me aback because of how many different competing priorities and interests there are. And that seems to be this kind of through line for all of this, is the prioritization element. But all that said, I think the Recycled Water Strike Team set about its purpose to examine the impacts to permitting and the impacts to projects being permitting and funding. And they did really great work dialoguing. We tried to get them connected to members. They conducted interviews and really gathered together a lot of important information for why these projects may or may not go forward, and what helps accelerate that. So, showing on the slide in terms of substantive comments, I just wanted to make a few remarks. The volumetric annual report of wastewater and recycled water, this has kind of been a recurring theme since these reports have come out, but we respectfully would request maybe the qualification at this point of this being Title 22 recycled water. There are some other applications for reuse that aren't Title 22, but I feel like by not including those in these graphical representations, it is undercounting what is being done on a recycling front. And so the kind of 2 things that come to mind are ag reuse. So you're having tertiary treatment, but not full advanced treatment with reverse osmosis, which is typical for the Title 22 front. But then you also have environmental flows. And so, there was a slide showing the level of effluent dropping, year over year from the volumetric annual report. And there's a bar chart showing, how far are we in this graph and how much is there to be achieved. But you really can't get a full counting if you don't put in, well, this water is being used for environmental flows. It's not even available. And this water is being used for ag reuse. And that kind of counts, it's not Title 22, but it's reuse. And so we want some kind of just formal acknowledgement or recognition of that when we're presenting on these numbers, so that the conversation is a more accurate conversation in terms of what and how much can be realized in the future, as well as to, pay respect to the past and what people have done in the past on this front to achieve those higher levels of treatment that don't maybe reach Title 22, but still should be counted because they are going towards beneficial uses. So that's one comment. And then, to the issue of, affordability, I think this one's really critical, looking forward. What's very apparent in my most recent conversations with members is that in Northern California, the priority for wastewater treatment is going to be focused on nutrient removal, whereas in Southern California, the priority is in water recycling and water supply augmentation. But what we're realizing is if there's this disappearing snowpack, and if agencies are going out for big projects to remove nutrients in Northern California, they might need to consider water recycling. And is it feasible to do 2-in-1 in a project? If you find that synergy and you find all the right circumstances to do a 2-in-1, you're looking at a project that could be something like $1 billion. The benefits are expansive, impacts a huge service area. It just costs a lot of money. And our SRF fund is only 600 million approximately as our annual sustainable capacity. So one big project could really eat up that capacity. And so that's a concern in terms of how are we prioritizing these issues. In Southern California, it's kind of the opposite. They're doing water recycling, but the most recent research that SWRCB kind of provided in terms of pursuing water recycling and ocean acidification and nutrient reductions show that unless you do nutrient removal along with recycling, the impacts to the environment were modeled and predicted to cause these circumstances to even worsen. And so it would lead to think that if you're going to do recycling, you're also going to have to deal with that. And then where it gets really tricky is if you're doing it, advanced treatment and you're removing nutrients from there, oftentimes you're diverting that into some type of treatment that's going to ultimately aerosize it. So it's going to become an air emission in the form of nitrous oxide potentially. And so it has to be a balancing and a weighing of what are these options in terms of your treatment, but all to say, this is going to result in projects that are very expensive and very costly. And so, our hope is that the bonds that are being discussed in the legislature would be able to provide some funding so that we can increase that capacity amount. I think from the analysis this summer that the board did, and they kind of showed it with their economic team, they modeled that a $500 million investment would result in an increase of almost 200 million per year. And on a timeline for what they modeled, it was essentially 500 million, and in a bond would translate to 2.5 billion in terms of funding that could get out the door. And so opportunities for that type of, for lack of a better word, leveraging is going to be very critical for the state to realize the projects that are going to be needed to meet the goals that are displayed here on the chart. So, with that, I would, just close out by kind of remarking on this notion of elimination of coastal discharges. And as we're working on doing recycling, just wanting to note that there really is no such thing as the elimination of a coastal discharge. You can treat the water and do advanced treatment and create a product water, but you're still going to have a reverse osmosis concentrate, that's going to concentrate anything that's removed out of there. So it could be a CEC, or it could be a nutrient, or a variety of metals or other items that couldn't get through treatment, that bypass other stages of treatment. And so as we're kind of talking through this, I also just want to be mindful of that component of what are the real opportunities. And in the case of the elimination of coastal discharges, that's somewhat of a fiction just by the nature of engineering. And so instead of really eliminating a discharge, what you're really doing is a shift. And so we're working on this concept of the media shift and being thoughtful about how we conduct those media shifts and which ones ultimately, are tolerable and which ones should be avoided. And we'll do this work in collaboration with you all on your team. But just to bring it back to the work to date, it's been really excellent work. Our members have felt like they've been heard, they've had access to the strike team, and the information they wanted to provide to answer the questions is being heeded. And so as we go forward into 2024 and beyond, CASA is here to continue working with you all on these fronts. And thank you for the opportunity to be involved to this stage.
Thank you as well. I'm looking forward to, I know what will be further work and a lot of complexity. What comes to mind certainly is the SWRCB modeling that was done and some of the discussion the board has had here to your point, as we recycle in the Southern California Bight, we're not so much removing nutrients as oftentimes concentrating them, and have further work to do. And just thanks. I appreciate the deep engagement and acknowledgement of folks listening. Board Member Morgan.
Thank you. So first, just want to also thank and acknowledge staff, for all the work that's gone into this. A lot of progress has been made within this past year and 3-4 months here. And then, just thinking back to Board Member McGuire's speaking towards, the stormwater program, and just looking at, and I also am really looking forward to seeing, the numbers and seeing just the data of, how much is available. And so that just, as Mr. Bosco was talking, I was recalling back to those comments and thinking about slide 5 here, which was showing the influent, effluent, and recycled water, and just, thinking about just how that picture shows it, you almost envision, hey, there's this much more that is available. And so it's almost maybe refining how we're showing that, and showing, hey, there's the Title 22, there's the non-Title 22 recycled water, but then really what is that available? What is left available? And that's what I believe, Board Member Firestone was also asking. There's the 2030 number, which you've refined, but then what, you're working on the 2040 number. And so maybe it's adding on, on top of there of what is available to, what we've identified, but then what do we believe is also available to recycle? Because I believe at the end of the day, it doesn't add up to the full influence, because you have to return some water back to the streams, to the environment. There's the amount that is not Title 22. There's the amount that is, the concentrated brine waste. There's these different amounts. And so it just helps to put that into a picture, so that when you're taking this quick glance at these great figures, I love figures, but when we're taking this quick glance at it, we can somewhat quickly see, oh, there's this, I'm going to say sliver, there's this piece of the pie that's left that we're still looking to capture and to work towards. So I just wanted to voice my takeaway from this conversation. If we can work towards having, and I know it's a figure that's going to be refined. It's something that we'll work towards. It's not something you can just go back to your desk and quickly come up with. But if that's something that we can work towards and then refine as we, as you're doing the recycled water, the updates, it would be helpful to me. So thank you guys again. I know a lot of work has gone into this. I know there's a lot of work to go. I'm just really grateful for what we've accomplished so far.
Here. Thank you, Board Member. Vice Chair.
I'll just chime in and say thank you. I think plenty's been said about the value of this, but I'll just add, it's great for us, because as we are out there talking with stakeholders and being messengers, it's really helpful to have more specifics. And so thank you for the report. I look forward to hearing more. And I guess I'll just chime in and, concur with some of the things Board Member Morgan just said, and Mr. Voskel about ag use. Where it has been used, where it doesn't reach Title 22, there are some examples in the state where it's made a huge difference, not just in terms of additional water supplies for agriculture, but also for specifically, there's a project in Stanislaus County where I live that when ag isn't using the water, it goes to the Grasslands Water District. And so there's just this synergy between balancing beneficial use, for multiple uses. And then I know that there continues to be interest, but because of in the San Joaquin Valley, but challenges because of costs. So I think putting this information, figuring out a way to include the information, I think can help to send a message that these are real projects and they do have value. And so for areas that think, they've been shut out of recycled water opportunities, in fact, depending on the mix of partnerships, it can happen. So thank you.
Really appreciate that, Vice Chair. Yeah, I think when you look at the volumetric amounts, folks automatically think to the large cities, the large projects that'll help get us there. And while, maybe not as big a contributor to the actual volumetric amount that we're looking for recycling, some of those projects in those smaller communities are some of the most important ones. So how we really see those amongst them as we even look at the big projects, I think is really critical. So thank you for that. Anything further from board members? I look forward to what I know will be further future report on this and engagement. I appreciated the slide with all the reminders of ways that folks can connect directly to the work as it continues to unfold, and just incredible thanks for it. So thank you. Thank you for the update. Really appreciate everyone's contributions to this. And that wraps our informational item number 6 on the water supply, water strategy implementation update. Let's now then quickly move. We have 2 items left for today's agenda. This meeting will continue on till tomorrow when we have our item on adoption for the Clear Lake Hitch informational order. But for now, we're on item number 7, board member reports. Would anyone like to kick us off?
I can start.
Board member Morgan, thank you.
So going back a little bit further, I missed the last board meeting. So we'll start off with October 26th. I participated in the California Water Environment Association's Young Professionals webinar. They did a webinar on, it was the introduction to the water boards. And so that was really cool. So it's something that one of their young professionals contacted me about, and she just said, I don't know much about the water board and I really want to learn. And I think there's going to be other people who do too. So would you mind doing a webinar with us and just, introducing us to the water boards and answering a few questions. And so I thought that was really neat. And that was a lot of fun to do. Then on the 27th, I participated in the Valley Visions industry event. And so that was basically water workforce development discussion. And so there was a few of us from different agencies, including DWR and the city of Sacramento. And there was one other, apologize, so it was a little bit ago now. And so just having just a discussion just about the water workforce and just the types of jobs that there are, the opportunities. Sacramento State was also their Office of Water Programs. And so just, again, a great discussion just about the different jobs and opportunities and not just the typical opportunities that we think of when we think about the workforce within the water industry. And so the reason why I was not at the last board meeting was that on November 3rd, the 3rd through the 9th, I actually was in Denmark. I participated in a high-level policy delegation on water policies for green growth in Denmark. That was just a great trip. Very just grateful and honored that I was able to attend and to participate. We had I want to talk about just a marathon trip, just starting off at about 7 a.m., ending past 7 p.m. So just get up, went to several meetings with their Minister of Environment, Denmark, EPA, also just several partners from Denmark water industry toured their water treatment plant, 2 wastewater treatment facilities. One was new, one was an aging facility that they are looking at actually replacing, not just refurbishing or renewing. They're actually looking at completely just replacing the facility. And so the new wastewater treatment facility was really interesting. It's actually totally enclosed indoors. I should have gave Courtney a slide to show this one. But it's indoors. It really is like in a building. The processes are in a building. Just beautiful architecture. You look at it and you're like, wow, that's a beautiful building. And so not just the normal Nicole, like, oh, it's nice, a great treatment facility, but it was like a nice building. And then the buildings actually have green roofs with walking paths and trails. And the neighborhood actually comes over and goes walking around the facility. And so what Denmark found is that the property values, the closer you get to the treatment facilities, decreased. So they decided to beautify their treatment facilities, and so that they could basically build homes right next door, and it would be a positive thing because you get this green space right next door, and you can come visit, and you have your walking trails and your paths, and just a beautiful space. And it really was a beautiful space, and that's just not from the engineer speaking from, ooh, I'm at another treatment facility. And so that was just really interesting to see just that thought process and incorporating treatment in the facilities within the communities and making it a community space. And so just great sharing, just lots of ideas and whatnot. Definitely, share a picture. Anyone wants, a picture of what that looks like. Definitely, I'm willing to share one that was, I don't know, that obviously it was a highlight of my tour, seeing something, a green roof on the wastewater treatment building. So, and then on, the other thing I just want to mention about that was that we had, so several meetings throughout, and during just that one, we were just talking about just, obviously was water policies for green growth. And we're just talking about just green industry and also recycling and just other concepts. And just Denmark actually, their homes, they actually have 10 recycling bins, 10 different places to, they sort in 10 different bins. So, that was just quite also remarkable. So they're definitely, just ahead. They're also their water systems. Sorry to keep going on here. I just keep thinking of more. But all of their utilities, the entire country actually is in a GIS system. So they bring it up and you can actually see the entire system. The map, you see the streets map with all their utilities within the system and what is going on. And they have a learning space for children to go to. And so you go to this learning space, I believe it was like the 5th grade or so, you go to this learning space, they have this map, and they also have hands-on tools where you can actually say, okay, well, what happens if you lost power at this space, in this grid? What happens to the utilities and what happens to the space? And also it shows, well, what happens, flooding and the utilities and your water system, your wastewater system. So that also was, my geeky self, I also had a lot of fun there with, seeing what happens. And so yes, it was an elementary school, thing, but it was a lot of fun just to see and be able to see just in real time what occurs throughout the country when different events occur. So that was also really nice. And then November 28th through 30th, I participated in the Association of California Water Agencies in Aqua and was on the panel, not on the panel, but I helped participate in facilitating a table for making conservation a way of life, and had a great conversation at my table with and there were some directors in different water agencies, and just helping the understanding of what the regulation is to do and what it would mean for the agencies. So that's it.
Thank you so much, board member, for representing us as always so well, but particularly in Denmark. I know we are fortunate that we have an MOU with Denmark and they invite us to come out, but really being able to get out, see a different society, truly a different location, and just get inspired is incredible. So thank you for connecting, and looking forward to what I know, is opportunity for follow-up with our memorandum of understanding that we have existing with Denmark. And I think, there's just so many threads worth following up on. So thank you for being that connection for us with them. Vice Chair.
Like a great trip, and I look forward to hearing more about the 10 bins. Okay, so I also attended Aqua and was a facilitator at the making water making conservation a way of life in California, and just appreciated the opportunity to be there because they took one of these phone surveys. How many of you here know much about the regulation? How are you planning on implementing it? It was just, in real time. And a lot of times, we hear directly from advocates. And there was the one night that we were here until 10 o'clock plus. But I was at a table where there were a number of people that hadn't been as engaged. And so it was just a good opportunity to kind of get a better sense of, the work that whatever we adopt, the work that we're going to have to do in terms of getting the word out and helping to provide water suppliers with the tools that they need to make this successful. Didn't hear anybody say, this is a bad idea, we don't want to do it. It was just an issue of how to. Went to earlier in the month, went along with most of the board here to the public meeting in Tulare Lake, and just been spending a lot of time meeting with GSAs and doing, I think, my small part, like we all are trying to do, to, really encourage greater focus towards sustainability, and just spent a lot of time at Aqua delivering the same message and, listening and learning. But we've got a big job ahead of us, and there's a lot going on. So those meetings are helpful to better understand local conditions, but also to be thinking through, I think, we're all going to be briefed on, thinking about process going forward. And so these have been good opportunities. And then I was able to participate in something in my backyard that I want to share with you. And that is the Stanislaus Regional Water Authority ribbon cutting for the surface water, the new surface water treatment plant. And I'm a water user in the city of Turlock. And I always get the annual reports, consumer confidence reports, and look up the contaminants, and am very concerned because we've got TCP 123. We have nitrates. There's some wells that have been impacted by arsenic. And so it was great to be there representing the board, but representing residents for this exciting change. And it made me, when I was standing there, I just kind of thought, gosh, thinking Board Member Firestone of, some of the work that you've done and how it's just really gratifying when you can be part of the community and see a change. This is a big project. It costs a lot of money. And I have a resolution that they presented to our board. I don't know where we're going to put it, but I'll let you decide, Chair, but they were very grateful for our support. And this is a community that's been challenged with some of the actions that we've taken in the past, on the Bay Delta plan. So it was great to be there in celebration with the community and to benefit when I turn on my tap.
Fantastic. Thank you, Vice Chair, and completely agree. As a native Californian as well, I know folks well know, I think at this point, from the Eastern Coachella Valley, and being able to work with our communities in the St. Bain and space, see change in this space is really, really rewarding. I'll quickly go. I was also with other board colleagues here at the Association of California Water Agencies. I participated in their Water Management Committee meeting, was able to give a good update on the water supply strategy and work we did, and agree that it's just good to be out there having conversations, listening, and just appreciate the great engagement that I know everyone continues to have in all the community work that is going on, and attendance of different events. And so additionally, on November 9th, I had a great opportunity to be a guest lecturer at UCLA. There is a water leaders class, kind of giving an overview of water. Alvar, who was with the PPIC, is a professor over there. He was kind to invite me over, and it's always a good opportunity in preparation for those moments to think about what is it that we're doing? How is it to best articulate and engage, especially with students who are here to keep us accountable and are tracking our issues very closely. So I really appreciated that. On November 13th, I was down in the Coachella Valley for the National Association of Regulatory Utility Commissioners. Was fortunate to be invited to participate in
their water committee panel and discussion and talked about, and Commissioner Shurma was there as well, and really was able to talk about the good consolidation work across to the PUC and ourselves, and a lot of the work the board was doing, and was fortunate to be invited. After that moment, I actually drove to Tucson because there's no real good flights and ended up taking a lot more time than otherwise. So drove to Tucson and participated in the One Water Summit, was on a panel on affordability. Joined Julian from Earth Justice, and the general manager for the San Antonio Water Authority, Water Agency, and Julia Ellis, who used to be with SFPUC and now with Promise, to talk about affordability and the work the board is doing, but also importantly to hear the great work that is going on nationally and how we're all able to connect to it. And that's it for now. Board Member McGuire.
Well, I have just been as busy as I have ever been as a board member. I don't know about you all. But actually I have very little to report. Officially, I haven't made any public presentations. I did attend Aqua last week as well.
Thank you, Board Member. We're in Firestone. Take us home.
All right. Let's see. A lot of themes going on here. Maybe I'll start with just a lot of engagement with tribes, which has been really great. I can't remember if I mentioned this at the last board meeting or workshop, but I was able to participate in an in-person meeting at Shingle Springs that our staff all participated in. And, Chief Deputy Oppenheimer was there, and many other staff for 5 hours sitting down and engaging, talking through stuff. And it was just, I think, a really good session, and helped lay the framework for, I think, continued good engagement and sessions and work that we have ahead on Bay Delta. And then I also was able to participate in and represent the board at the Clear Lake Hitch Summit in around Clear Lake, that all of the tribes in the region helped host, and there were representatives from most of the state and federal agencies there, and really great session. I think, specific recommitments from everyone to continue the work of the task force, which is really a model for how we've been able to move forward in a really coordinated manner in that region. And I think a testament to why we're seeing progress that we are around work on better understanding the drivers around the hitch and moving forward on progress. But focus areas are around enforcement, data and monitoring, regulatory efforts, and stakeholder engagement and facilitation. And our staff provided some good updates on that. And I think just reiterated, I reiterated the commitment this board has around the hitch, and, we have an item tomorrow on that. But I know that's been an issue we've had in our priority list and continue to. And then affordability, other big theme for me. I spoke with the Metropolitan Water Districts Board's Committee on Equity. I'm not sure the full title, but they have had a series of meetings around affordability. So talk to them. They're particularly interested in regulatory drivers around affordability. And also am going to participate in the CFE. I don't remember what that stands for, but I know focus here now. But convening on a panel around affordability as well. And was able to participate in the PPIC panel focused on recharge. And I think lastly, I'll just mention, I mentioned this before, but I'm continuing to to follow and try to support efforts down in Tulare County with East Rosie and Color Rosie, where their community of East Rosie's wastewater system and drinking water systems have been failing. Staff are doing really great work. It's challenging when you have, the same entity that's both drinking water and wastewater and it's failing, because we have authorities around drinking water that we don't have around wastewater. And I know staff are going to be, have been working hard to make sure we're providing assistance and getting consolidations moving forward there. So continuing to engage on that. And I think there'll be more to come with the board as well on that issue. That's it.
Thank you so much, board member. That wraps up board member reports and brings us to our executive director's report. So Beck.
Thank you, board members. I wanted to give Karen Mogus the opportunity to provide an update on something she sent you all an email about, but just it is not included in the executive director's report because it came up at the end of last week when the report went out. But just an update on where we are with the supplemental arrearages program.
Yeah, thank you. So just to reiterate the email that I sent you so that the public can hear. As a reminder, you adopted the guidelines for the extended arrearages program on October 3rd at your board meeting. We on time got the application out on November 1st for a 60-day comment period. Did some outreach along the way to encourage facilities, both wastewater and water. This time it's all one package to apply for the $600 million that's available to help with customer debt associated with the COVID pandemic, with the extended arrearage period going out to December 31st, 2022. So just wanted to give you an update on what we've received so far. We have 30 as of last Thursday, so I didn't check this morning. We have 30 complete applications to the tune of $87.6 million, which is far below what we have available. By way of comparison, we had over 800 applications during the water and wastewater arrearages period or arrearages program the first time around. And so we're well below where we could be, or well below what's available in terms of the funding. So we're going to conduct additional outreach this week, contacting all of the applicants from the first go round directly and encouraging them to apply. We do have 34 more applicants that are in the hopper, so we do anticipate doubling the number that we currently have, but that's still not going to be enough to get there. So just wanted to give that. I also wanted to provide an update on our interactions with the CSD on their LIWAP program. They have extended the program through March of 2024. And I know that there has been concerns about sort of double paying for customer debt. They are able to pay for customer debt outside of the extended arrearages period and are intending to make sure that their funds are only applied outside of our arrearage period, so there isn't a concern of double paying. So that conversation continues and has been very positive. So just wanted to give a quick update and answer any questions you might have on the arrearages program while I was here.
Yeah, I just really appreciate you elevating this. I know I've had a number of conversations when I was at Aqua at that management committee meeting. I know there's an intense amount of interest from the water community around conservation and just concern that, there's only so much space out there, and would like to see a lot more attention brought to this as well. So as we can make sure that we really bring the most benefit to households and communities right now, even as future potential impacts to affordability or considerations are also thought of in the conservation space. But there's immediate benefit that I hope water agencies that are consistent in their concern are availing themselves of just as much.
I couldn't agree more. This is really a building block for us. And so it's important that the program be successful. So just curious, Is it, not that you would necessarily know the answer to this or not, but is it that there may not be as much need? And if there's not as much need, are you sensing just prioritizing that, because they wouldn't be applying for as much in this round, that it's not worth their time? And if so, is there anything that can be done to assist with streamlining, providing the old application and seeing if anything needs to just be changed as opposed to starting over?
Yeah, I don't have a sense of the reason why some facilities aren't submitting applications. That may be something we can query them about as we do our additional outreach in the next week or so, and get a sense of what might the barriers be. And so, yeah, I can follow up on that.
Can I follow up, building on that? So have we already done one round of direct letters to everybody? And this is a second round that we're doing. Okay. And then last time there was a place on the website where the public could see who'd applied. Do we have the ability to do that this time around?
We have the ability and the intent, and it may be up. I just don't know off the top of my head if it's actually there. We have talked about it.
Okay. Yeah. I think that's really helpful because, I know it's nice. A lot of folks are doing it. So there's no need to be bugging them, but I think if there's folks that aren't, some follow-up and additional touches from, folks outside is helpful. And then, we did a lot of work, I think also through some of our media work. And I can't remember if we've done that as much this year or this time around, probably not as much, but I think we did do some kind of media release.
Yeah,
Can you
we've
just
been
remind me?
working with Amy Crunson and her team and Jackie on getting the word out. We probably can do more, just alert people, hey, we're halfway through the application period. If you're at all interested in and have customers that have need, you need to apply.
Yeah, I really appreciate it. And I just appreciate the update and like coming out at this point while there's still time on so we can, and the additional push we have.
Yeah, we'll keep pounding the pavement for sure on that. Okay. Thank you very much, Ms. Mogus, and thank you, Ms. Sobek. That wraps up the Executive Director's report and our items for today. The board will be going into closed session here in a bit. We may take a short break, probably before we do so. I'd say maybe just a 15-minute break for folks between here. And then so otherwise, we will be in recess until tomorrow morning at 9 a.m. when we will begin consideration of our proposed resolution for emergency information order regulations for the Clear Lake watershed. Thank you, everyone, for what's been a good day of discussion here. Look forward to seeing you all tomorrow. Again, we are recess, and in about 15 minutes, we'll enter closed session. And Mr. Law, for anything?
No, just for the board members to find where we're going to meet today.
Oh, yes,
Closed session.
we'll be in 2:30.
Conference room 2:30 over
around the corner here. So. All right. Yeah. Don't go up to the 25th floor. All right. Thanks, everyone. Appreciate it. Or you can, but no one will be meeting up there. We will be in recess and we will get back again in about 15 minutes and 2:30 for closed session. Thanks again. See you tomorrow morning.